For the First Circuit is now in session. All persons having any business before this honorable court may give their attendance and they shall be heard. God save the United States of America and this honorable court. Today's cases will be called as previously announced and the times will be as allotted to counsel. The first case today is Ghassan Alasaad et al. Versus Chad F. Wolf et al. Appeal number 20-1077 and appeal number 20-1081. Attorney Waldman, please introduce yourself for the record and begin.
Thank you. Good morning, Your Honors. My name is Joshua Waldman. I'm here from the United States Department of Justice, representing the appellant and cross-appellee in this first case. The district court correctly rejected any requirement for probable cause and a warrant for a border search of an electronic device. No court has ever required that level of suspicion for any border search, whether of an electronic device or anything else. But the district court erred in holding that a quick look at a few texts or photos requires the same reasonable suspicion as a comprehensive cataloging and analysis of gigabytes of information stored on a device, including deleted or encrypted data. 3 circuits squarely addressing this question have correctly rejected that view, holding that heightened suspicion is required, at most, only for a forensic search, but not for manual searches. The district court likewise erred in holding that a border search permits a search for contraband, but not for evidence of contraband smuggling, and thus an electronic device can only be searched for digital contraband. The border search exception is grounded in the long-standing right of the sovereign to prevent the entry of contraband. Searching for evidence of contraband smuggling serves that purpose just as much as searching for contraband itself, since both may lead to interdicting the contraband before it enters the country. The plaintiffs never offer any persuasive reason to the contrary, and instead base their argument entirely on a case that the Supreme Court overruled nearly 50 years ago. The district court in this case improperly entered a blanket rule where any basic search, no matter how minimal or unintrusive, for example, a brief look at a single text or email, required reasonable suspicion. The 3 circuits that have addressed this question make clear that that is incorrect.
Counsel, let me ask you this question. The plaintiffs in this case were seeking a declaratory judgment that the directive or directives issued by the department or its sub-agencies were unconstitutional because of various perceived shortcomings. If we were prepared to hold that the directives themselves are lawful, is it necessary for us to go beyond that and reach the constitutional issues? Or can we simply dismiss the declaratory judgment action or affirm the dismissal of it or order the district court to dismiss it?
I think that you can do as you suggest, Your Honor, and not necessarily reach all of the underlying constitutional questions. Right. Before I go on, I was remiss in my introduction in not asking the court for 5 minutes of rebuttal time. If it's not too late to do so, Your Honors, I'd like to reserve that time.
Yeah, you may have it.
Thank you, Your Honor. I appreciate your leniency in that. Judge Selya, I think you're right that if you were to find that the directives themselves and in their overall distinction between basic and advanced search generally comply with the constitutional standards and could resolve the question in this case, I don't think that you need to go on necessarily and lay out all the precise constitutional requirements so long as the directives would satisfy any constitutional standards that may apply.
Okay, and one further question. In your opening remarks, you distinguished between basic searches and forensic searches. I take it your reference to forensic searches is not meant to differentiate forensic searches from what the parties have been referring to as advanced searches?
That's exactly correct.
Okay.
I think that is, as the Fourth Circuit noted in Culsas, the import is the same between that terminology and the ones used in the directives. While they're not entirely coextensive, for purposes of resolving this case, I think there's such a practical alignment that the difference in nomenclature is immaterial for resolving the issues before this court.
Thank you.
You're welcome.
Counsel, I now have some questions. Were any of the plaintiffs in fact searched after the date had their equipment searched pursuant to these directives after the effective date? You, in your briefing, seems to suggest that 2 of them were, but when I read the complaints, I did not see that. Can you clarify?
Yes, Your Honor. There were 2. One of them submitted a supplemental declaration, which is why you won't find it in the complaint, but you'll find it in appendix at page 352. The other post-2018 search, you'll find it at appendix page 149. I will note that both of those searches that were conducted after 2018 were alleged to be basic searches, not advanced searches.
Okay, next question. Even if the directives are thought to meet any reasonable suspicion requirement, the district court nonetheless limited the scope of the searches to less than the statutory authority given to the agencies for searches. You also, I believe, argue that the actual judgment issued did not adequately provide for sort of a terrorism exception to any suspicion requirement, or adequately consider all of the exigent circumstances. So I take it, following up on Judge Selya's question, you think those issues would need to be addressed?
I think they would not need to be addressed, if I heard your question correctly. And the reason is that that exception was not invoked in this case at all. As you just noted, most of the searches, except for 2, occurred before 2018. And the national security exception, which is, I think, what you're referring to,
yes,
didn't exist prior to 2018, so could not have been invoked for the simple reason that the exception did not exist.
Okay.
After 2018, both searches were basic searches. And since the national security exception is to reasonable suspicion required for an advanced search, for that reason, the exception would not have been relevant. Because, in other words, they were basic searches, therefore no suspicion was required under the directive, and it follows from that no exception for reasonable suspicion would have been required.
That's right.
So for that reason, I think it's completely, doesn't have anything really to do with this case.
All right. Now, how do you understand the plaintiffs to differentiate the Fourth Amendment issues from the First Amendment issues?
Well, to be honest, Your Honor, I'm a little bit confused about what their First Amendment argument is. As we said in our brief, I think the Supreme Court in TJ Video rejected any higher Fourth Amendment standard based on First Amendment concerns. And both the Fourth and the Ninth Circuit have applied that specifically to border searches of electronic devices. In their reply brief, the plaintiffs say they're not asking for a higher standard. In fact, they say they're not really asking for a rule that protects expressive activity writ large. So I'm not really sure what their argument is or where it comes from. It seems to be a rule that applies only to expressive content only when it exists on a cell phone. I don't know where that comes from in the First Amendment or the Fourth Amendment, but no court, as far as I'm aware, has accepted it. And it would just create a huge hole in the Fourth Amendment, which is why at the border, which is why the Fourth and the Ninth Circuit both rejected any such argument.
Okay. Unusually, all of the other circuits have dealt with these issues in the context of motions to suppress in criminal proceedings. This is a civil case, not a criminal case, that seems to have aspects of a facial attack and possibly as applied attacks. Hypothesize for a moment that a journalist presents a claim under the First Amendment, independent of the Fourth Amendment, that he is being targeted for the anti-government articles he has written, and that he would not have been subjected to, he or she would not have been subjected to either a basic search or an advanced search, but for that targeting. On your position, is it open for someone in the future to make an as-applied attack along those lines?
I suppose that it is, but I do want to emphasize that the district court made a specific factual finding in this case. That there
4
was
minutes remaining.
Thank you. There were no evidence of targeting based on speech, and that the directives are content neutral on their face. Now, so I take it that you're making a hypothetical, but I do want to emphasize that this is not at all the facts of this case. But I think the hypothetical that you pose would likely be a straight up First Amendment challenge and not at all a Fourth Amendment challenge. And so if you had that in a proper case, you could look at it. But like under the First Amendment, as under the Fourth Amendment, if extreme hypotheticals are presented in a case, the courts can deal with it. But there's no reason to answer hypothetical questions in this case that are not presented on the facts. And in fact, there was a specific factual finding unappealed by the district court that said there was no targeting based on speech in this case.
All right. You have to forgive us judges, but we always worry about the limits on any opinion that we are asked to write. So I'm going to give you no, I'll withdraw that. I take it the government policy applies regardless of whether the person entering or exiting is an American citizen.
That's correct, Your Honor. And 10 of the 11 plaintiffs in this case were citizens. The 11th was a lawful permanent resident. But the Supreme Court has made clear that the border search exception applies to citizens and non-citizens alike.
All right, but two of the amicus briefs deal with foreign nationals who are not lawful permanent residents, and we don't have those problems in this case. Is that correct?
You do not, because they're all the plaintiffs are citizens or lawful permanent residents. Right. That's correct. But Your Honor, I want to circle back to one of the questions that Judge Lynch, or comments that you made, Judge Lynch, about worrying about hypothetical situations. I certainly don't think that you should be deciding this on hypotheticals, but when you look at the particular facts of this case, one of the things that's most notable about the plaintiffs is the dearth of facts alleged in their complaint and stated in their statement of undisputed material facts. Most of the plaintiffs don't tell you anything about what was searched, how much was searched. Some of them don't tell you how long it was searched. In fact, one of them just says my phone was searched, and that's all the evidence. And yet the district court and the plaintiffs want a blanket rule that applies to each and every search, regardless of the factual situation. In fact, that was a strategic litigation choice by the plaintiffs, who during discovery disclaimed any need for discovery into the specific facts of the case precisely because they wanted a blanket rule that treated the most minimal basic search under the same constitutional standard as the most comprehensive advanced search possible. And
do I understand you to be saying that therefore the way the plaintiffs have framed the case, we have a facial attack in front of us and no possible as applied attacks?
I don't think that it's impossible to construe it. I do think a facial challenge here, and certainly one was made, is easily disposed of because there's clearly some set of facts in which a phone can be searched without suspicion if it's looking at a single text, for example. But as for the as applied challenge, that fails as well. May I complete the
finish? Yes.
That fails as well because the dearth of facts does not remotely establish anything close to what other courts would consider a border search of a device that requires reasonable suspicion. It doesn't come anywhere close to the so-called forensic searches.
Okay, one other question. Although you take out after the plaintiffs for not providing a lot of facts, in fact, the litigation started before the directives were issued, and indeed, the bringing of the suit may have had something to do with the directives. I looked at what you provided as legislative history within the agencies as to the origin of the directives. There's not an explicit reference to the Fourth Amendment. Did I miss something?
An explicit reference to the Fourth Amendment in the directives?
As a basis for the change in position that the directives now offer.
Well, I do think that the agency took the view that they did not necessarily think advanced searches require reasonable suspicion under the Constitution, but they did take note of the cases. And in fact, if you look at the guidance that ICE issued, which is in the addendum, not the appendix, there is a specific reference to the Fourth Circuit case in Colses. So the agencies certainly were aware of what the circuit courts were doing with respect to the constitutional requirements of cell phone searches, of device searches.
Okay, so I take it your position is we are not conceding that even for advanced searches, the Constitution requires reasonable suspicion, but because the directives require reasonable suspicion for advanced searches, the constitutional issue is not before the court.
I couldn't have said it better myself, Judge Lynch. That's exactly correct. And that's, for example, what the Supreme Court did in Ramsey, the search of mail, where they said the regulation does not allow the Postal Service to read the mail without a warrant. And since the regulation doesn't allow the government to do that, we don't need to reach the constitutional question of whether the Fourth Amendment would additionally prohibit what the government's regulation also prohibits.
Okay, thank you.
Thank you, Your Honor.
Attorney Waldman, at this time, you can mute your device. Attorney Bhandari, please introduce yourself to the record.
May it please the court, Aisha Bhandari for the plaintiffs. I would like to address two main points today. First, this court should hold that the Constitution requires a warrant for electronic device searches at the border, but at a minimum, it should uphold the district court's ruling that the Constitution requires at least reasonable suspicion of digital contraband. And second, this court should hold, as the district court correctly held, that the rule should be the same for basic searches as for advanced searches, because basic searches are extraordinarily invasive and do not advance the government's legitimate interests in warrantless border searches. I would like to turn...
Excuse me, counsel, with respect to your first point,
Yes.
we would be the first court, were we to follow your counsel, to hold that a warrant requirement applied at the border. Isn't that so?
Yes, Your Honor. This would be the first court to hold as a categorical matter that a warrant is required
Yes,
for all
well,
device searches.
that's what you're asking us to make that holding as a categorical matter.
Yes, Your Honor. Just
Right.
as this court so held in Worry when it became the first appellate court to hold that search incident to arrest of cell phones requires a warrant and was unanimously upheld in Riley. But I want to turn to the government's arguments about reasonable suspicion. And I want to note a couple of things. First, the directives do not comply currently with the rulings of all other circuit courts. The Fourth Circuit in Cole-Sue's, first of all, explicitly reserved the question of what standard applies to basic searches. It did not say that basic searches can be done in a suspicionless manner. And then in Egbakan, the Fourth Circuit decision that was decided 1 week after the district court opinion in this case, the Fourth Circuit said, actually, you cannot conduct warrantless border device searches to advance pre-existing domestic investigations. In that case, border agents searched someone's cell phone looking for evidence of a purely domestic trafficking investigation. And the Fourth Circuit said you need a warrant for that search, even though, in fact, officers had probable cause at the moment that they searched. The government's directives do not comply with that requirement. And similarly with the Ninth Circuit.
Counsel, we've got two different types of searches here. We'll use the government's nomenclature, the basic search and the advanced search. There is nothing in your brief that contests the government's assertion that for advanced searches, the directives in fact comply with reasonable suspicion. You do say that you're still concerned about it because the directives do not provide a private cause of action. But as to the question of whether the advanced search directive complies with reasonable suspicion, you did not contest the government's assertion. Are you now contesting it?
With respect, Judge Lynch, we did make the argument that the directives do not, in fact, require reasonable suspicion because of the national security exception, which permits them to conduct suspicionless searches under that vaguely defined exception.
And why is that issue in this case?
Well, Your Honor, the plaintiffs have raised, a justiciable controversy that they have faced device searches in the past, and that they are at risk of future suspicionless device searches, as the district court found based on the facts here. And
have any of the plaintiffs been exposed to what you're referring to as national security searches?
Your Honor, we don't know.
I don't recall anything in your complaint or even in the discovery that would say that.
Well, Your Honor, the complaint was filed before the
Yeah,
directives.
I understand that.
And I think the point, because we are arguing that as a categorical matter, not as an as-applied matter, that all of the plaintiffs remain at risk of these future searches without suspicion, they do remain at risk that the government could invoke that particular exception, which is vaguely defined and does not require suspicion of wrongdoing, to search the plaintiffs. But I want to emphasize that
they remain at risk of 1,000 different things, none of which are raised in this case. I mean, we need an actual case or controversy, not an imagined one.
Yes, Your Honor. And the district court correctly held that the plaintiffs have standing to challenge the policies and practices writ large because they are at risk of unlawful searches
which
under
is
them.
the government's use of the reasonable suspicion standard for advanced searches and their use of no standard at all for basic searches. I understand you can challenge those 2 points, but it seems to me you're bringing the national security exception in from left field, that there's nothing in this case that puts any such exception validly in issue.
Your Honor, even if we leave aside the national security exception, the plaintiffs have challenged the lawfulness of the reasonable suspicion standard with respect to advanced searches. And so as as numerous courts have
No,
found.
no, please. You keep sort of circling around.
Yeah.
Let's put aside your answer that, well, yes, we did in fact challenge reasonable suspicion for advanced searches as to the exception for national security. Now, let's assume that national security issue is not in front of us. So I go back to my question. If that's not in front of us, are you contending that the advanced search directive does not itself require reasonable suspicion? And if so, what is the basis for that?
I apologize, Judge Lynch, and I think I understand your question correctly. The plaintiffs argue that even if the directives require reasonable suspicion, that does not comply with the constitutional requirement because it must be reasonable suspicion of digital contraband, as the Ninth Circuit held in Canyo. That is the, if a warrant is not required, that the digital contraband limitation.
No. Please, once again, there is a distinction between the scope of the search and whether you are contesting that the policy itself requires reasonable suspicion. Thus far, I am not hearing any argument that the policy itself does not require reasonable suspicion. You are now on to a separate argument as to what they are permitted to search for using a reasonable suspicion argument, the standard. And you are saying it's limited to actual evidence of contraband. Do I have that correct?
Yes, to the extent that we are arguing that it is limited to evidence, not to evidence of contraband, but to a search for digital contraband itself.
Okay, so why should this court adopt such a standard?
Judge Lynch, we think it is important that the court narrow the scope of permissible search for the reasons that the Judge Bybee's opinion in Canyo laid out. So that searches are closely tethered to the historical interest that permitted warrantless searches at the border. Judge Bybee's opinion noted that the primary interest that justifies warrantless searches is the search for physical contraband, and that the search for evidence is not closely tied to that. And there are, two concerns in particular if the search can be for more than digital contraband. First, it allows for general rummaging through private and personal information in people's devices, of the sort of general search that is one of the main concerns behind Fourth Amendment's protections. But second, the record in this case shows that the government admits that it can conduct searches of travelers when the person of interest is someone other than the traveler. So a reasonable suspicion requirement of any violation of a law enforced or administered by CBP and ICE means that the agencies can and do search, for example, a journalist's phone because they are interested in the activities of a source, or a business person's phone because of the activities of their associate, a family member's phone because they have reasonable suspicion about the family member, not the person themselves.
Okay, can I go back to an argument your brother made? He said, as to your plaintiffs who were actually subjected to the policies, it was merely a basic search. It was not an advanced search, correct?
He's referring to the two searches that took place after the
that's what I just said. Yes. Right.
Some plaintiffs have been subject to advanced search, and the plaintiffs do contest that those basic searches are also unlawful when they are done without reasonable suspicion of.
And so no advanced searches were done of any of your plaintiffs which involved looking for evidence directed to possible criminal activity by third parties, correct?
No, Your Honor, that is correct. But that is the record evidence that the government's policies permit this. And
okay, so now I'd like to move on simply because we don't have a lot of time. Okay, so I have been struggling with the distinction between the Fourth Amendment analysis and the First Amendment analysis. And absent any targeting or any form of retaliation against someone for speech that they have engaged in, or the press, is there any distinction between the two analyses actually presented in this case?
Yes, Your Honor. The First Amendment requires an independent analysis. And the best analogy I can give you to the nature of our claim is the concern that the Supreme Court articulated in Ramsey in 1977, decades ago, when it noted that if, in fact, customs officials were permitted to read all incoming international mail without suspicion, that would raise the specter of chilling First Amendment freedoms such that a warrant requirement could protect against that. So that the Supreme Court was so concerned about a regime of reading correspondence that was coming over the international border as to float the possibility of this First Amendment problem requiring a warrant. That was not about targeting individuals. The concern wasn't that journalist correspondence would be opened, a lawyer's correspondence would be opened. That was just the chill on Americans' freedoms generally, knowing that.
Okay, so now let's work backward from that premise to, if the government had reasonable suspicion, would there in fact be a First Amendment problem?
Your Honor, I think that a reasonable suspicion of digital contraband requirement would go a long way to protecting against the chill on First Amendment freedoms, because individuals would then be confident when they cross the border that their correspondence, that their emails, that their texts and photos won't just be searched at the whim of an officer or without any suspicion of wrongdoing on their part specifically, and that the searches will be limited. Because when an officer is searching through a phone, of course, even if an officer is looking for specific things, what they are likely to see are hundreds of emails, calendar invitations, notifications about medical appointments. Looking through photos, you see a lot of personal, intimate family photos, even if you're searching for specific things. So limiting the scope of the search would really go a long way to protecting against those First Amendment harms. Again, the journalist would then not have to worry as much that an officer could just look at their emails for source information, because that would not be about a search for digital contraband. A lawyer, a defense lawyer, as was raised by the AMICI, the National Association of Criminal Defense Lawyers, and others, they wouldn't have to worry that their files on their laptop would be searched for wrongdoing by their clients, because they know only a permissible search is for digital contraband that they themselves are carrying. So we do think that limitation would address the First Amendment concerns. I do want to raise one other issue.
I'm sorry. Under the Fourth Amendment, there are exigent circumstance exceptions. Are you suggesting under the First Amendment there would be no such exceptions because regardless there is a chilling effect?
No, Your Honor. The exigent circumstances exception to any general rule applied would still be available. And I don't think that would have a chilling effect because, again, exigent circumstances requires certain factors. And one of the key factors, of course, is suspicion of wrongdoing by the person.
5 minutes remaining.
The key, of course, to a chilling effect is when people who have not done anything wrong and therefore cannot control the fact that an officer might search their information. That's the key. So as soon as you enter in the realm of exigent circumstances where officers generally are dealing with a situation of wrongdoing or potential harm, the mine run of innocent travelers who cross the border need not be concerned about that, and that need not raise a general First Amendment concern.
But doesn't the reasonable suspicion standard in and of itself address that concern?
Judge Selya, do I understand you to mean reasonable suspicion but absent a digital contraband limitation?
Yes.
That would be an
If
important...
there is reasonable suspicion to believe that an individual is carrying evidence of criminal activity, right? Not digital contraband, but evidence of criminal activity. It seems to me that is in itself a protection against the kind of general rummaging that you seem to fear. Because
I
that
think
suspicion has to be targeted, has to be aimed at the individual traveler. There's got to be some reason to believe that he or she has in his or her possession that evidence.
Your Honor, I think that a reasonable suspicion requirement alone would certainly go some way to protecting against the First Amendment chill problem. You noted that it would have to be reasonable suspicion of the traveler themselves, and I just want to emphasize.
Say of the traveler. I said that the traveler himself or herself possessed the evidence. It wouldn't necessarily have to be his or her wrongdoing, but that he or she possessed the evidence. That would be the key to reasonable suspicion.
I understand. Okay. I think that would still raise First Amendment concerns, and particularly...
No, first, why? And second, why is that issue in this case?
I'll just raise the example of journalists and attorney-client privilege.
We don't have a journalist subjected to an advanced search.
Well, Your Honor, we also, I want to emphasize, we also challenged basic searches. The plaintiffs have said...
I know that, but we're talking now about the reasonable suspicion requirement that the directive places on advanced searches. So let's not complicate matters beyond that. To my recollection, the record doesn't even fairly raise the question of any journalist who has been, or any defense attorney, or any of the other hypotheticals that you can spin out at length, who has been subjected to any advanced search under a reasonable suspicion requirement. I mean, you're asking us to really give you an advisory opinion as to how this might work in such an instance.
Your Honor, it is correct that we're not alleging specific attorneys having been searched, although you asked a question about whether the directives require this, and the district court did note...
I'm sorry to interrupt, judges. I wanted to make sure that Judge LaPlante is still on the line. Judge LaPlante?
I am on the line. I can hear everything.
Great. Thank you so much, Judge.
Thank you.
I'm not sure if that's good or bad for you, Joe.
So far, so good, Judge.
Okay.
The district court judge correctly noted that the plaintiffs raised a facial challenge to the policies, but I understand if you are interested in whether these specific plaintiffs' experiences raise the specific advanced search concern. Right. No, we do not allege that. We say that facially these policies do not comply with the First Amendment.
Okay, thank you. That's helpful.
And I have another, pardon me, perhaps hypothetical question, but Judge Selya said if there was reasonable suspicion that the information on the electronic device had to do with the commission of a crime. Now, the district court limited this to contraband. Yet Congress has authorized the border agents to search and intervene in a number of crimes, what used to be called white slavery is now called, transport of people for illicit purposes across lines. There are all sorts of other worries that Congress had, and so they authorized these searches. But you seem to think that Congress's power to authorize these searches is limited by a historic understanding of old Supreme Court cases that were concerned with contraband, and that is somehow a limitation. And I don't understand that. Could you tell me why you think that that's the correct way of understanding this?
Yes, Judge Lynch, I will try to do so. First of all, we don't dispute that Congress has given CBP and ICE the authority to enforce a host of laws. Congress has not specifically given it the authority to search devices at the border, so I want to be clear about that, but it has given it the authority to enforce laws. But the key question is whether the warrantless search authority can extend to that whole host of authority. That's the constitutional limitation. And this court—
where in the Constitution is there any such limitation? The only thing I've derived from your argument is a limitation that you think is inherent in the historic function of border searches at a time before Congress had authorized all of these other activities. Is that the sole basis for it?
There's also the multiple Supreme Court opinions since then, from Montoya de Hernandez to Flores-Montano, that have reiterated that the warrantless search authority at the border is limited to certain limited purposes. And in fact, in Flores-Montano, the Supreme Court left open the possibility that some border searches might be per se unreasonable under the Fourth Amendment. And in Riley, the Supreme Court analogized the search incident to arrest exception to the border search exception as a category of warrantless search authority that the government has, but which must be narrowly tethered to its justifications. So the Supreme Court, reiterated its understanding that warrantless search authority are exceptions to the Fourth Amendment. Thank you, Your Honor.
Judge LaPlante, do you have any questions now that you've been able to join us visually as well as through auditory means?
No, Judge, not any questions that you haven't already covered. Thank you.
Okay. Thank you, counsel.
Thank you.
If Attorney Waldman would please unmute at this time. There's 5 minutes of rebuttal. Please reintroduce yourself for the record.
Good morning again, Your Honors, and it's good to be able to see all of you now. Joshua Waldman for the United States. I'd like to just begin with the question of that the holding of the Ninth Circuit in Cano or Cano, however it's pronounced, about digital contraband. The argument was made in Cano and is made here, but I haven't heard the Ninth Circuit or the plaintiffs really give any kind of persuasive answer about why searching for evidence of contraband smuggling doesn't serve the government's purpose of interdicting contraband before it enters the country. To me, that just doesn't make any sense, and I haven't heard a sufficient answer to that. I also want to point out the sweeping nature, the potential sweeping nature of what that rule would mean if you couldn't search for evidence. Because when you look beyond the devices in this case to what the CBP does on a normal day, and with COVID, we're not in normal times, but in normal times, they're searching billions of dollars of cargo shipments are coming in every day. And the CBP demands bills of lading, invoices, all kinds of paperwork regarding the cargo before it can enter the United States. All of that is evidence, not contraband. And if you can't look at evidence, then you couldn't look at any of those things. So they're proposing a rule which would have potentially sweeping consequences for the border search exception. In addition, the plaintiffs talk about a question about general rummaging for general law enforcement purposes. The CBP's directive specifically says they must have reasonable suspicion of a provision that CBP enforces which means that it's going to have a nexus to the border, which is exactly what the Fourth Circuit said in Colsus is proper and fine. So you don't need to consider anything about purely domestic offenses. It's not an issue in this case. Although I would note that some circuits, including the DC Circuit in Gurr, which is cited in our brief, and the Second Circuit in a 2015 case called Levy, said that you don't even need that restriction for the CBP. That was outside of the context of a digital device, but it was within the context of a border search. We're not asking for that rule in this case because the directives wouldn't permit us to do it anyway. But I do think that there's no basis at all in Cano. It's just reviving a distinction from Boyd that the Supreme Court overruled in Hayden because it had no basis in the constitutional text, was an unworkable rule, and it had no relationship to privacy concerns that underlay the Fourth Amendment. I'd also like to address briefly the First Amendment question and just correct the record a little bit. My opposing counsel refers to Ramsey, the mail case. In fact, the Supreme Court didn't reach the underlying First Amendment question about reading the mail. But everything the court said suggested that would not be a constitutional problem. And the court explicitly rejected the argument that mail is different when it comes to the border search exception. They said there's no reason to think an internationally mailed letter is different from a letter that you carry in your hand over the border, and that the privacy concern should be any different such that they would override the government's interest at the border, which, as the Supreme Court has said, is where the government interest is at its zenith. So I don't think that the First Amendment argument carries any weight here, certainly not from Ramsey. And in fact, the plaintiffs in their reply brief at page 21 say they're not even asking for a rule for all expressive activity, just expressive activity that's on a phone. And I don't understand where that distinction would possibly come from in the First Amendment. And just to return one last point about Cano. There was a question I believe Judge Lynch posed about whether the plaintiffs have made any allegations that what was looking at in this case was mere evidence as opposed to searching for contraband. And the answer to that question, I think, is you wouldn't know, precisely because of the dearth of factual allegations in the complaint. In fact, even when they say something like you looked at an email, there's no indication of whether you were looking at an email because you thought there was digital contraband in that email, as was the case in Cotterman and other things where that would be perfectly permissible, or whether they were looking for evidence. There's just no.
Mr. Waldman, in fairness, how are the plaintiffs going to know what the border officer has in his mind when he does the search?
Well,
really?
I think that's actually part of the problem with the Cano rule, which is what the Ninth Circuit said in Cano is, at least when it comes to a basic search for which you need no reasonable suspicion at all, you can look anywhere where digital contraband, quote, may be. And one of the problems with that rule is it's very difficult to know how a judge or a border officer is supposed to determine where digital contraband, quote, may be, because it is often can be hidden, purposefully hidden within a digital device, as
That's
it was.
time.
Finish your answer.
So, Your Honor, I think that you should reverse the judgment of the district court in terms of both its blanket rule between a basic and advanced search and its reliance on the rationale in Cano. If there's any further questions, I'm happy to answer them.
Yeah, you seem to be saying not only reverse, but vacate the relief that has been given, the declaratory judgment, correct?
That's correct.
All right. Thank you.
Thank you, Your Honor.
That concludes argument in this case. Attorney Waldman. The next case today is Carlos Antonio Granados Benitez versus Jeffrey Rosen, appeal number 20-1541. Attorney Alston, please introduce yourself for the record.
Good morning. My name is Paige Alston, appearing on behalf of the petitioner, Mr. Granados. May it please the court, I would like to reserve 2 minutes for rebuttal with the court's permission.
Yes, you may.
Thank you. Shall I begin?
Please.
Mr. Granados is asking this court to direct the Board of Immigration Appeals to apply its well-established precedent to his case, precedent that the government concedes that the board did not apply here. Mr. Granados is a crime victim. He has applied for a U visa, which is a visa available to victims of serious crimes in the United States who assist law enforcement in solving those crimes. And in light of his pending application for a U visa, he did precisely what the motion to reopen statute contemplates. He filed a timely motion with the court, with the immigration court, seeking to reopen his case in light of new evidence.
Well,
And
wait a minute. Excuse me, counsel. You said he filed it with the immigration court? I thought he filed it with the BIA.
You're correct, Your Honor. He did. He filed it with the Board of
And
Immigration.
what relief did he request from the BIA? The government appears to think it important that he didn't specifically request a continuance. What relief did he request from the BIA?
Your Honor, he sought reopening and remand back to the immigration judge. So okay. I'll begin with what he did not seek. He did not seek termination. Termination is a remedy available if the U visa were approved, which he did not allege that it was. And termination is a remedy that the board would grant. There would be no reason to remand.
But he sought reopening and remand to the IJ. And the assumption I would imagine is that if that were granted, he would then ask the IJ for specific relief.
That's exactly right, Your Honor. Okay. He alleged the facts that are crucial to the analysis of whether the immigration court should await his pending collateral visa. He's filed this visa with a different agency, with USCIS, and the board, under the board's case law that begins with the Sanchez-Sosa case in 2012, if he can establish certain elements, he's entitled to a legal presumption that the court—
Ms. Alston, just a couple of things. Isn't it the usual practice that continuances are granted by immigration judges rather than the BIA? Right? The BIA is an appellate body, right?
Yes, you're exactly right. The immigration
so
judge
to be able to ask for a continuance, it's got to be remanded to the immigration judge. Okay. Secondly, the amicus has pointed us to a USCIS directive that seems to say if you are put on a wait list, as your client was, that then is the normal circumstance for the removal proceedings to be stayed. So putting together your argument and the additional information we've been given about USCIS, it would seem that there are two inconsistencies in the board's decision. The first has to do with what you've been arguing, that their prior precedent, their practice, and the second has to do with sort of the left hand and the right hand not apparently knowing what the other is doing. Which is USCIS has one interpretation of what it means to be on a wait list, but the BIA seems to have another one. Have I basically gotten the argument?
Well, you are correct that we rely on the board's prior precedent to argue that
4 minutes remaining.
That this legal presumption is triggered here and that he should have more time. The issue with the USCIS directive shows that essentially when it issues the type of letter and makes a waitlist determination like it has, that does show that the visa is prima facie approvable. And of course, under the Sanchez-Sosa case and its successor cases, that should be the primary factor that the board should look at when considering whether to wait for CIS to do its job and to ultimately adjudicate the visa.
Does it make any difference that Sanchez-Sosa arose in a different procedural posture?
It does not, Your Honor, and I'll answer that that point with two points. The first is that every court of appeals to have looked at this and the board itself have found that the Sanchez-Sosa framework applies in the motion to reopen or the motion to remand posture. And I'd like to note here, because the government points out that among the 4 other circuit court cases we cite and the amicus cites, 2 concern motions to remand. But motions to remand filed with the board during the pendency of an appeal, but putting forward new evidence and asking for a remand back to the judge, the immigration judge, motions to remand are treated by the board and by reviewing courts exactly the same as motions to reopen. And that has been the case for decades. What we see in all of those cases is that the courts of appeals find that Sanchez-Sosa is the test to apply. And indeed, I would note here that the LNY case, which is the board's 3rd precedential case in this line of cases interpreting Sanchez-Sosa, is itself a motion to remand case. There we see the respondent in immigration court, like Mr. Granados, puts in evidence that his U visa is approvable and he asks for a remand, and the board accepts and considers that evidence and then applies Sanchez-Sosa. And so what we see is unanimity applying that framework in this posture. And I would just further note, as we say in our reply, that stands to reason given how motions to reopen are adjudicated. The relevant prong in the motion to reopen test asks whether the individual has shown prima facie eligibility for relief. And so that prong of the inquiry requires this court or the agency to posit that the person is back before the immigration judge, hypothetically, and to ask if there's a reasonable likelihood that he or she would get relief. So essentially, the standard is providing the bridge back to whatever the criteria are or the framework will be for the immigration judge in making that determination. And so we are asking here that this court join every other court of appeals to have looked at this, as well as the board in much of its previous precedential and non-precedential practice, and find that the Sanchez-Sosa case controls this inquiry, and to direct the board to apply it, which, as I say, the government has agreed with us that the board did not.
I just have a question about the scope of the vacate and remand that you want. Are you also arguing that had the board applied Sanchez-Sosa, it would have had no choice but to remand to the immigration judge, and that therefore the remand to the BIA should also include an instruction to send it back to the immigration judge?
I apologize. We are, Your Honor, we are asking that this court direct the board to apply the Sanchez-Sosa framework, but we do think that on this record, there is only one reasonable and appropriate outcome that the board could reach given application of that standard, because the crucial issue is whether he's shown that the visa is prima facie approvable. And the agency has not contested that. Indeed, in LNY, the agency called the type of letter that he has dispositive of that question, and none of the countervailing factors.
But there is a value in orderliness of procedure. You asked the board to remand this to the IJ. The board refused to do that. All right. If your position is correct, and we say that it was error or an abuse of discretion for the board to refuse to remand, it seems to me that that's as far as we ought to go. At that point, it is up to the immigration court to apply Sanchez-Sosa. I don't have any reason to believe that it won't do so, but we shouldn't pretermit that decision when the immigration court has never had an opportunity to make it.
Your Honor, you are correct that the board has not had an opportunity at this point, or the board, I should say, had an opportunity. The board has failed to apply the Sanchez-Sosa case.
But the board was just asked to remand. You say that was error. that they didn't remand. All right, it's the IJ who would then have to grant the relief beyond the remand, isn't that so?
That's absolutely right. The immigration judge would adjudicate whether a continuance is warranted here. When I say that we think the record shows he's made a prima facie case, we think the record shows that
all of that may be true, but I don't understand why that's our concern. Our concern is whether the board's order ought to be reversed or vacated, and the case sent, and the board ordered to send the case, to reopen the case and send it to the immigration judge.
That is exactly the relief that we seek, Your Honor, would be a reopening and remand to the immigration judge to adjudicate that continuance request.
Okay.
Thank you.
We'll hear from your opponent now. You have 2 minutes reserved.
Thank you. At this time, would Attorney Bates please unmute your device and introduce yourself on the record.
Good morning, Your Honors. Christopher Bates for the respondent. DHS regulations provide that a petitioner who has an approved U visa petition and has a final order of removal may seek cancellation of such an order by filing with the immigration judge or the board a motion to reopen and terminate removal proceedings. Here, the board properly applied this regulation.
Well, Mr. Bates, there was no request here to terminate removal proceedings. This was simply a request to reopen for the purpose of remanding to the immigration court. From the papers, it's evident that the purpose of the remand was to enable the petitioner to bring to the attention of the immigration judge the fact that the petitioner had been placed on the waiting list for U visa approval, and that the petitioner was stuck in that position because the U visa quota was filled for the present year. There was no request to terminate removal, and all of the policies and the case law that have been called to our attention indicate that being placed on the waiting list, all right, would have constituted sufficient reason for the IJ to have granted a continuance or some similar relief, which, because of the board's action, the petitioner never had a chance to ask for. That's what the problem that I see is with this case.
I understand, Your Honor. I would note, of course, as we have explained in our brief, that the petitioner did not expressly request a continuance for purposes of the
the board wasn't the agency or the tribunal to grant the continuance. The petitioner did exactly what the petitioner ought to have done. He requested reopening and remand to the judge who was in a position to entertain a continuance request.
And expressly sought the continuance for purposes of the I-130. It's not clear from the motion, Your Honor, that he was seeking expressly for a remand for purposes of continuance with regard to the U visa. And if I may briefly, Your Honor, as well.
I'm sorry, but why did he have to specify that to the BIA when he's saying remand to the IJ so the IJ can consider this under the normal rules of the agency? Your client seems to have been confused about what all of this was really about. So I'm not actually quite sure why the government has chosen to defend this case.
Well, Your Honor, I would note as well that in the petitioner's motion to reopen, that petitioner also did not cite Sanchez-Sosa or seek application of the Sanchez-Sosa factors. So as to the question of, the relief that petitioner was seeking in the motion to reopen, it was reasonable for the board to understand it in the way that it did.
The petitioner was seeking a remand. That's what his motion said. That's the only thing he was seeking from the board. And that was the proper thing to seek from the board. And the petitioner didn't have to cite Sanchez-Sosa to warrant that. The board was well aware of the department's own directives and of the facts of the case.
That's correct, Your Honor. I think from the board's decision here, the board did understand the petitioner to be seeking with regard to the U visa reopening for purposes of termination. Again, the petitioner didn't use the word termination in the motion, didn't use that word continuous with regard to the U visa. Did say he was seeking vacatur and that he should not be removed. But if I may move on, Your Honors, to application of Sanchez-Sosa here. I think it's important to note that there are, of course, multiple factors.
5 minutes remaining.
Thank you.
Go ahead.
There are, of course, multiple factors that come into play in Sanchez-Sosa. The board has said that prima facie eligibility and the likelihood that the collateral relief will make a difference in the proceedings, those are the primary factors. There are, of course, secondary factors that can outweigh those primary factors, as was the case in L and Y. And so as the question of if this court determines that the motion to reopen is properly construed as seeking a remand for purposes of continuance, as we have argued in our brief, the appropriate thing for this court to do would not be to remand for instructions to grant continuance, but for the board to determine how Sanchez-Sosa should apply in the context of a motion to reopen. As Your Honors know, motions to reopen, and this is stated in the Supreme Court's Abudu case, are heavily disfavored given the interest and finality of litigation. Petitioners bear a heavy burden. The board has elucidated the factors that should be considered by an immigration judge in determining whether to grant a continuance in pending proceedings. It has not addressed that issue in the context of a motion to reopen. And
I don't understand why there's anything further for the board to do. Let's bear with me, and let's assume that this court is prepared to hold that the board either erred or abused its discretion. I think it's abuse of discretion in denying a motion to reopen and remand in these circumstances. Why is there anything further for the board to do? It then becomes the immigration judge's obligation when the immigration court is confronted with the next motion, which we all anticipate will be a motion to continue, to apply whatever precedent is available and to exercise whatever discretion the immigration judge has and make that decision. But I don't understand why there's anything further for the board to do. It's not the board which is being asked to grant a continuance. The board is merely being asked to reopen. And certainly given the department's directive, the USCIS directive, it seems to me that there is good reason for reopening this case. There has been a significant development that on the face of things is likely to provide the petitioner with some relief that was not available for him to seek at the time of the original immigration court proceedings.
Yes, Your Honor. I think that the relevant consideration is how those Sanchez-Sosa factors would apply given the context here is a motion to reopen. It could be the case that application would be similar as in pending proceedings. It could be the case that certain factors should receive slightly different weight given the heavy burden that movements face with regard to motions to reopen. I think that our point or position, Your Honor, is simply that given that the board has not previously addressed application of the Sanchez-Sosa factors in the context of a motion to reopen, it would be appropriate for the board to do that here to provide further guidance to the immigration judge, again, if this court were to construe the motion to reopen.
If I've understood your position, you believe that the board has the discretion, because it was a motion to reopen, to issue a stop or go order. That if it says stop, the immigration judge never gets a chance to consider any of the factors, because the board has said no, motions to reopen are categorically can't be used. On the other hand, if they say go, then it goes to the immigration judge and he considers the factors. Normally, the board prefers to have an immigration judge take a first look at these issues, and then they look at whether that judge committed an error of law. What I don't understand is the premise that you're arguing from, that the board has the discretion to now come up with a categorical rule that motions to reopen are somehow different and excuse the board from doing what it ordinarily would do.
So, Your Honor, it's not that we would anticipate or would say, although it would certainly be the board's decision, it's not necessarily we would anticipate a stop or go decision, but that the board would provide guidance as to how those 5 or 6 factors from Sanchez-Sosa should be applied here, whether they should be applied in the same fashion as in the context of a continuous motion in pending proceedings, if certain factors should be given more weight. For instance, if the administrative efficiency interests might be given different weight given the motion to reopen context. And so it's not, no.
That's time.
Yeah, go ahead. But boy, it strikes me that what you're doing is contrary to what Congress intended when it gave this type of relief to people who were here. If you happen to be a victim of a crime before your immigration proceedings have closed before the immigration judge, well, then you're eligible. But if you happen to be a victim of a crime thereafter, and it's obviously new circumstances that could not have occurred earlier, gosh, well, then you're out of luck. It just strikes me as being inconsistent with what Congress was trying to accomplish.
If I may just clarify 2 things, Your Honor. I understand that I'm out of time at this point. It's not necessarily that you're eligible in pending proceedings, not eligible afterwards. Again, it would be a question of how the Sanchez-Sosa factors apply. If the weight is the same as in pending proceedings, if there may be some different application. Secondarily, as the USCIS directive that the Your Honors have discussed makes clear, it is the policy of the agency, once an individual has been placed on the wait list, not to remove the individual. And what the board said in the decision here, I think it's a proper reading of the board's decision to say that the board understood the petitioner as, although the petitioner did not use the word terminate, was seeking an application of that regulation.
No, counsel. Yeah. I'm sorry. I just don't read it that way. I read the board as saying, okay, you can be removed, but if someday you move up the wait list, then you have a chance to come back to this country. And we do know that the agency removes people in all sorts of circumstances when they shouldn't have been removed. And it seems to me your position is, well, once the removal order is out there, BIA is just hands off.
I understand, Your Honor, and I would simply emphasize again then that the agency has stated that its policy is not to remove folks who have been placed on the waiting list. The regulations do, of course, also provide for a stay for individuals to seek a stay of removal from the agency while they are in pending proceedings. So there are, various avenues that individuals can seek protection under the regulatory scheme and the agency's policies. Thank you, Your
Okay,
Honors.
thank you.
Thank you, Attorney Bates. You can mute your device at this time. Attorney Alston, please reintroduce yourself for the record.
Paige Alston for the petitioner, just with a few brief points in response. I'll start with the government's point that motions to reopen are disfavored. I think Judge Lynch said exactly right here that that would run contrary to congressional intent, and that's not only because of the U visa, but because of the motion to reopen statute. This is a timely motion to reopen. Congress created a very narrow exception for when motions to reopen can be granted when they're filed within 90 days with new previously unavailable evidence. And that is exactly what Mr. Granados has done here. Whether he has other avenues of relief open to him administratively or through a current policy of the agency cannot vitiate that right given to him by Congress under the statute to file this timely motion to reopen and ask that his case be reopened. And the second point that I would respond to is the government has said a few times that the board might, upon looking at this again, decide to weigh the Sanchez-Sosa factors a little bit differently. And I would just repeat our point that that's not how the motion to reopen test works. The motion to reopen test asks whether the individual is prima facie eligible before the immigration judge. And so that necessarily draws on whatever the case law is that the immigration judge will use. When this court reviews a finding by the board that an individual is or is not, for example, prima facie eligible for asylum, we don't ask what the requirements are for asylum in the motion to reopen context. We ask what the requirements for asylum are, full stop. And so to here, this court or the agency, if it's properly doing its job, should look at what the standards will be before the IJ. Those are the Sanchez-Sosa standards. There's no reason to reweigh them or to come up with a different test. Just exactly as Your Honor said, there's nothing left for the board to do here. This case should have been reopened and remanded to give Mr. Granados an opportunity to seek a continuance while his meritorious U visa is pending.
That's time.
Thank you, counsel.
Thank you.
That concludes argument in this case. Attorney The next case today is Gerald Alston versus the town of Brookline, Massachusetts et al. Appeal number 201434. Attorney Ames, please introduce yourself for the record.
May it please the court, Brooks Ames representing Gerald Alston. May I reserve 2 minutes for rebuttal?
2, yes.
The question for the court is whether Gerald Alston, a veteran firefighter terminated by the town of Brookline, who has since been reinstated to his position by the Massachusetts Civil Service Commission and the Massachusetts Superior Court, has established trial-worthy claims of racial discrimination under the Equal Protection Clause and retaliation under the First Amendment in connection with his termination. The district court ruled Alston failed to present competent evidence challenging Brookline's account of his termination. The district court, applying the familiar McDonnell-Douglas framework, ruled effectively that it was undisputed that Brookline officials had acted in good faith and for legitimate, non-discriminatory or retaliatory reasons in terminating Alston, and that no reasonable jury could find otherwise. The district court erred in that finding.
Mr. Ames, this is a really complicated case, so I'm going to try to move us along. Let's assume, please, that the district court's non-mutual collateral estoppel ruling is wrong. Let's just take that as a hypothetical, and that the earlier actions do not preclude suit against individuals. Before we get to whether there is a trial-worthy issue of fact, I would just like to go through each of the categories of the defendants. Now, as to the union, they argue that events before December 1, 2012 are time barred. Do you agree with that?
No, Your Honor.
All right. As to the events after December 2012, which has to do with the leave being painted on the fire trucks in 2013 and the events leading up to the termination. Can you focus in on that and tell us why you think, as to the union, which says, look, we really weren't involved and we weren't asked to be involved, why you think you have a claim against them? These are not questions of disputes of material fact. These are basic, have you alleged enough facts about union involvement to keep them in the case? Okay?
Yes, thank you, Your Honor. With regards to the union, the core allegation is the union betrayed its duty to protect Mr. Alston from discrimination within the union. And that included discrimination that took place on the union blog, which the union controlled. So initially, it was a retaliatory act by Joseph Canny, who records show was the vice president of the union, who put on the Facebook blog early after Mr. Alston was referred to as the N-word by his lieutenant. This Joseph Canny, vice president of the union, put on the union blog that firefighter Alston was a faceless coward and that his claims were meritless. So that's
Mr. Ames, that assumes that you're correct that the pre-2012 December events are time barred. Let's assume you're wrong about that. Okay, what is the claim against the union? And then I have other defendants I want to get to. Okay, yes. What's the claim against the union thereafter?
The next claim against the union is that in connection with the leave incident that Your Honor noted, the union actively worked against firefighter Alston and tried to get the town to essentially declare him as dangerous by putting police cars at every fire station and by having the town execute a stay-away order against him.
Okay, fine. Excuse me. I've got it. I'm just trying to understand these things. All right. Let's move on to the individual Brookline defendants sued in their individual capacity. Okay, There is no claim under Section 1981 against individuals. Agreed?
Yes.
Okay, so that drops out. Okay. As to the 1985 claims, they say you didn't brief it, you've waived it. Can we agree on that?
Well, insofar as we're alleging a conspiracy between the individual defendants, no, but I think that that would be supported under 1983 anyway as a joint action.
So all we're talking about are the 1983 claims, putting aside the speech claims against the individual defendants. What's the guts of your case as to the 1983 claims, as to the individuals?
The guts of that claim are what the commission found, which was that the individual...
Summarize it for me, please. We don't have a lot of time.
The individual defendants had an obligation to repair the breach caused by Lieutenant Pender's use of the N-word. That breach created a dangerous situation in the fire department because firefighters have to depend on each other for their safety when they do life-threatening tasks.
Okay, I've got it. How about the retaliation for the exercise of speech against the individual town defendants?
The retaliation is terminating Mr. Alston. The retaliation is terminating his pay, which happened on 2 occasions. That is effectively the retaliation.
Okay, and they say, look, we relied on outside expert psychologists who basically said in order for him to be able to return to work, he's got to comply with certain conditions, and he didn't comply. So it's a sort of Mount Healthy type defense on your First Amendment claims that would also work on the 1983 claims. What's your response?
The response is that the individual defendants presented a misleading picture to the experts by failing to disclose to the experts relevant information that affected whether firefighter Alston could safely return to work, including documents that demonstrated that
they, in their individual capacities, dealing with the experts, presented misleading information as opposed to whatever the town did in its official capacity. What evidence do you have of that?
The evidence is that they condoned the action of presenting a limited...
5 minutes remaining.
No, counsel, I think you may be missing Judge Lynch's point. All right. There may be evidence, the evidence to which you point may indicate that certain action or inaction occurred by the individual defendants in their individual capacities, but what in their official capacities. But what evidence do you have of any action or inaction on their part with respect to the expert taken as individuals and not as representatives or officials of the town?
Let me try out an answer to that, which may not be satisfactory to you, but with regards to the individuals, they're obviously acting and perceiving information because of their position in the town, but that doesn't mean that they didn't obtain that information. And the example I'm thinking of is that the individual's defendants invited Paul Pender, the lieutenant who had left the racial slur on Mr. Alston's voicemail, to a meeting so that Lieutenant Pender could plead his case. And in the course of that meeting, it became quite apparent that Lieutenant Pender was not remorseful for his actions. In fact, he was resentful and had a grievance against Mr. Alston. That was information that the individual defendants knew because they were getting it firsthand from Paul Pender. But then they rely in terminating Mr. Alston on a narrative that firefighter Alston has not been able to move on from the incident and that Pender has repeatedly expressed remorse. So these are parts of the record that show that the experts didn't have the full picture, and the individual defendants knew the experts didn't have the full picture.
Okay, I think we understand the
Yeah.
theory. Whether it's adequate is another matter. As to the Brookline selectmen in their official capacities, their first defense is there's no municipal policy or custom, and furthermore, there is no causal link between any such policy or custom, and that lets them out. What's your response to that?
The response to that is under the Supreme Court precedent in a number of decisions, including Pembauer. An action by a policymaker is a de facto policy. So when the selectmen, or it's now the select board.
Okay, suppose we disagree with that. What is the policy or custom adopted by Brookline which caused the various problems which your client admittedly suffered from?
The policy would be.
It is not the case that simply because somebody can enact policy that they are acting as policymakers for a city or town. So what is the policy or custom that was involved here?
Well, the policy is protecting a unrepentant racist and not taking the breach caused by racism seriously and not repairing it, which they had a duty to do.
Okay, then they say you've got to have some comparators to show differential treatment, and none of your comparators are in fact comparators.
Well, with regards to comparators and equal protection, it seems to me the entire purpose of the Equal Protection Clause was to protect Black people from discrimination.
Counsel, that doesn't help. Give us some names. Who are the precise comparators, and what's wrong with the argument that they are not really comparators? Believe me, this court knows what the Equal Protection Clause is about. We don't need lectures on that.
Thank you, Your Honor. There is not going to be a comparator because there is no word in the English language that is comparable to the N-word as applies to white people. So there is not going to be a white person who was called some slur, who was allowed to return to work without conditions, or who was treated better than Mr. Alston under similar circumstances.
Okay, so you're saying as to white comparators, the comparator test is simply wrong, okay? What about other minorities? Is there any evidence of other minorities differentially treated after they have been called racial slurs?
You mean in the same fashion as Mr. Alston?
Yes, yeah.
There's evidence in the record
Go ahead.
There's evidence in the record that a Black police officer was terminated after being called the N-word.
And the name of that officer?
Prentice Pilot.
Okay, thank you. Okay, sorry, I've interrupted your argument. I think you have a few minutes left if you'd like to finish on anything else.
Well, I think what I'd like to stress is that there are material issues of fact that the commission decided in Mr. Alston's favor, and that if a jury credited the commission's decision, which it could, then they could find in Mr. Alston's favor. And that these arguments—
That assumes, of course, that the commission decision is admissible. Is that correct?
Yes, it does. And
excuse me, as I understand the record, and I haven't yet looked at it because it's compendious, that what was before the district court was the commission decision, not the underlying commission record. Is that correct?
That's correct in the sense that I submitted primarily the 83-page report of the
Right.
commission
Okay.
and not the underlying record. The
Okay.
town, in response to my submission, our submission of the report, submitted the vast majority of the administrative record.
Okay.
But the argument is that this court in Davignon versus Hodgson said that commission reports, such as the one in this case, are admissible evidence under the hearsay exception in the federal rules, and that this report qualified under those rules to be admissible, and that the judge, the district court judge, failed in not taking into account the facts that were presented to the commission and the facts that were found by the commission, and that a jury that credited those facts or found those facts independently would be entitled to find that Mr. Alston was discriminated against on the basis of his race, and that Mr. Alston was retaliated against for continuing to press the issue of racial discrimination in the town of Brookline.
All right, so you're not arguing that the Civil Service Commission finding itself precludes the defendants from making their arguments. You are merely arguing that it is evidence that the district court should have considered, did not consider, and if it had considered it, it would have understood that there are material issues remaining in the case that could be decided in your client's favor. Have I got it?
Yes, Your Honor. Particularly the question of bad faith, which is a stand-in for pretext, which is typically what you have to show in order to get
No,
the
I'm
juries.
sorry. You lost me there. Why is bad faith a stand-in for pretext? One can have a legitimate reason to terminate employment. One can, in bad faith, decide that you're going to rely on that reason because you want to get rid of somebody. But that does not make the reason pretextual. You have some case that says pretext equals bad faith, and that following that a civil service use of the term bad faith is the equivalent of the federal question of pretext?
Well, I think in both, I don't have a case, but in both cases, Your Honor, it's really a question of credibility that is usually left to the jury to determine whether or not the reasons given for an action were the true reasons. And in the case of the Civil Service Commission, they had an opportunity to look the decision makers in the eye and make a determination as to whether or not they were credible when they said that they had been acting in good faith, essentially, in trying to bring firefighter Alston back to work. If they're not acting in good faith, that means they're being disingenuous about their underlying motivations. And that allows a jury to infer that the real reason is what Mr. Alston's alleging, which is that they were acting in retaliation and in
okay, and
discriminatory animus.
that's against the town and official capacity selectment, correct?
Yes, but it's the same officials as individuals who are making the decisions, and they have all the same
I have that. What
information.
about the union? The
As-
union did not terminate your client.
No, but the union failed to protect Mr. Alston and the union also participated in retaliation against Mr. Alston. And I'll just refer back to the leave incident in which the union lobbied over the fire chief, the fire chief had determined that this was not a situation that required police attention. The fire chief was able to go, the union was able to go over the fire chief's head to the town of Brookline and was able to get a stay-away order. The union then purported to represent firefighter Alston at a disciplinary hearing which laid down all the conditions that led to his termination, and didn't defend him at that hearing, and didn't grieve that hearing, even though firefighter Alston expressed dissatisfaction with the result of that.
Okay, I have that, but what does that have to do with this sort of Mount Healthy defense?
I'm not
The
sure.
union is not responsible for the expert psychiatric reports.
No.
Well, the union's not responsible for the reports, but the union did not ensure that firefighter Alston had due process in connection with the preparation of those reports. How many years back the doctors were looking at medical records and such.
Okay, got it. Did your client request union intervention at that point? As I read the union brief, they say he didn't.
They say he didn't, and we think that there's a material dispute of fact over what in this particular fire union was required to get the union to start working on your side. And it's our position.
Again, that's too general. Is there any evidence that your client requested union intervention as to the materials that were to be provided to the expert psychiatrists who look at him and say before he comes back to work, he ought to comply with these requirements?
The evidence is that at the hearing where the expert's report was presented to Mr. Alston in the union, Mr. Alston expressed dissatisfaction with the outcome, and the union was silent and although it was purportedly representing him, took no action.
Okay, thank you.
Attorney Ames, at this time, you can mute your device. And
yeah, you have 2 minutes rebuttal later. Okay.
And so, Attorney Ames, you can mute your audio and video at this time. And Attorney Podolsky, if you could introduce yourself for the record.
Good morning, Your Honors. Joseph Podolsky. May it please the court, I'll be speaking on behalf of the town of Brookline, the individual select board members in their official and individual capacities, and Town Council Jocelyn Murphy and HR Director Sandra DeBow. If I may proceed?
Please.
Thank you, Your Honor. Your Honor addressed a few of the perfunctory points I was going to make, and there are a few others that I wish to raise. First is the appellant appears to concede claim preclusion ruling of the lower court as against the town. And the appellant admits that he did not argue issue preclusion applied to the Civil Service Commission before the lower court. There are 4 main points that I'd like to make in oral argument today. First is the appellant has not offered specific and competent factual support for the premise that underlies his entire case. That is, he was subjected to a hostile work environment under the prescripts of the law. 2 points to highlight this issue for today. First is that this court's cases all hold, and the cases I'm specifically referring to are Forrest versus Brinker, Wilson versus Mollison, North Corporation, which is a case with a particularly nasty set of facts, Espinal versus National Grid Holdings. Those cases hold that employer defendants, such as the town defendants in this case, would be liable if they knew of discrimination and failed to take prompt and appropriate remedial action. And in those cases, prompt and appropriate remedial action was an investigation, a verbal warning, a written reprimand, and in one of the cases, termination for the bad actor's 3rd strike, which included both a slur and physical harassment. Here, the town defendants investigated, disciplined the bad actor with a 2-week suspension, anger management, sensitivity training, mandatory mediation, and immediate transfer. The chief at the time, Peter Scarry, warned all of the workers no retaliation. The town enlisted the assistance of the MCAD to come in and train the entire town workforce on anti-discrimination and bias training. The town enacted a town-wide zero tolerance anti-discrimination policy. One of the appellant's arguments is that Lieutenant Pender, the bad actor in this case, was not told, as in the other cases, that he would be fired. The entire department was told there was zero tolerance for anti-discrimination when the town issued to every member of the workforce, including the fire department, the anti-discrimination policy that said there's zero tolerance for discrimination. These are acts that took place prior to the Norfolk Superior Court case and judgment, but the Norfolk Superior Court case and judgment speaks to this point as well. And I'll get into that more in a second. The second main point that I'd like to make for today is the undisputed evidence. And the evidence truly is undisputed. The statement of facts, which are in the appendix before you, before the court, is largely, almost completely undisputed by the appellant. The undisputed evidence of the town defendant's legitimate and non-discriminatory reasons regarding the discrete actions, the discrete adverse actions taken in this case, is also undisputed proof that the adverse actions were not a pretext for discrimination. So it touches upon two elements of the McDonnell-Douglas test, and it touches upon the Mount Healthy defense as well. Specifically,
deal with Mount Healthy, please.
Yes, Your Honor. So specifically, December 19th and 22nd, 2013, the appellant admits he made shooting statements to his colleagues in the workplace and then told the chief, when the chief came in to meet with him that same day, that he too could get caught in the crossfire. The chief then hence placed him on leave pending psychological evaluation by an independent medical professional. And the appellant agreed that that was the appropriate action and that he felt it was necessary as well. That evidence goes to the second prong of the McDonnell-Douglas, the second and third prong of the McDonnell-Douglas test and the Mount Healthy line of precedent. And
we frequently skip the prima facie test and get to pretext. If you're familiar with our case law, you see that we do that all the time. That's why I'm trying to direct you.
I understand, Your Honor. And I only mention it because the specific factual defense applies to both tests, the pretext test and the Mount Healthy test. And on May 14th, when the chief issued the appellant the 2-day suspension that you spoke about with my brother counsel and conditioned his return to work, it was conditioned upon Dr. Brown's evaluations. He did 2 evaluations. The conditions were regular treatment, release for the occupational health nurse to monitor that treatment, completion of an anger management course, satisfactory passing of a fitness for duty evaluation, and random drug testing because of the cocaine and marijuana found in the appellant's system on multiple occasions over the course of years. Chief Ford also advised the appellant that he was no longer under investigation, that his administrative leave would end, and he would be carried on sick leave. That goes to the Mount Healthy defense. The appellant agreed in testimony that the chief's actions were not discriminatory or retaliatory. No appeal was taken. Appellant places blame with the union. I'll leave the union to argue to that on the union side of things, but the appellant could have filed an appeal to the Civil Service Commission without the help of the union. He didn't do so. And Amtrak versus Morgan, another Supreme Court case, speaks to such a failure to grieve discrete acts. Further, there was no second MCAD case filed. The record also shows that the appellant began to comply with the chief's conditions. It wasn't until November 2014, when he retained his current counsel, that he began to refuse the chief's conditions, and he sought to revive the Norfolk Superior Court case, which brings me to my third point. The Norfolk Superior Court case, and this is the third main point, and judgment is applicable in more than one way. The first is that the town answered and defended the claims, engaged in substantial discovery, and the court entered a judgment against him as a sanction for his refusal to provide answers to interrogatories, very specifically refusing to provide specifics, the who, the what, the when of his hostile work environment claims. When the court compelled him to do so, he still refused. The case law, Treglia versus McDonald, an SJC case, says such dismissals are with prejudice on the merits. The rules of procedure, in fact, Mass Rules of Civil Procedure, Rule 41, codifies that. Such sanctions are dismissals with prejudice on the merits. But the second point is that it goes to the Mollison versus North Corp holding, which is that notice must be provided. And in this case, not only was it not provided, but he was refusing court orders compelling him to provide that information. The second sub-point that I'd like to make on this point is that this undercuts the reliability of the Civil Service Commission decision. The commission expressly rejects the Norfolk judgment, sets it aside. Not only does it set it aside, but it uses these so-called shunning instances, the details of which were first provided in 2019 before the commission, to make unqualified medical findings as to stressors and hold them against the town.
Counsel, do you have an argument that the ultimate loss of employment, independently of what the Civil Service Commission did and independently of what the Superior Court did, is a Mount Healthy situation because of the town's reliance ultimately on these reports? Are you making such an argument?
Yes, Your Honor, I am. On behalf of the town and the individual defendants. Thank you, Your Honor. The decision to the 5 factors were put in place based upon Dr. Brown's independent medical advice in the early part of 2014. Chief Ford put those discrete decisions in place, those orders in place in May of 2014, and the appellant accepted those or appeared to accept those conditions. When he was going back to the fitness for duty evaluation with Dr. Brown, and he had his new counsel, if I may, Your Honor.
Bring us up to the termination in 2016, quickly.
So he objected to Dr. Brown, and the town went and got Dr. Price. Dr. Price evaluated the plaintiff, gave him a full and fair opportunity to provide whatever information he wanted to provide, and issued a decision with 3 very similar conditions, all of which he rejected. But there was no claim and there's no finding that Dr. Price was tainted in any way by any of the individual defendants or the town, or with any sort of intent to discriminate. That was the basis for the termination, essentially, almost a year and a half later, at the end of 2016. There were repeated opportunities to attempt to engage the plaintiff and his counsel. The town enlisted the assistance of Juan Cofield, the head of the New England chapter of the NAACP, Mamleo, Charles Walker, the former chair of the Massachusetts Commission Against Discrimination, the chief, the chief's successor. The town enlisted the MCAD again to do refresher training. The town conducted a race climate review of the entire department, invited the appellant's assistance.
What does that have to do with the expert's final decision? You're relying on Dr. Price's decision, are you not?
Yes, Your Honor. That ultimately has to do with the third prong of the doctor's decision, which is for the appellant to suggest to the town what reasonable accommodations he may want for his return. And he made no such suggestions, and yet the town took all of these steps to show to him that it was serious about eradicating race discrimination in employment. And ultimately, when he continued to not speak to various town officials, not get back to them, not show up to appointments, to meetings, ultimately a hearing was scheduled before another independent hearing officer, James Lamke, who heard facts and evidence, gave the appellant an opportunity to testify, to present whatever evidence in any form he wished to present, and he presented nothing. His counsel read a statement, and that was it. And so the opportunity to present this evidence was there, and he presented nothing. And so the hearing officer made a finding that relied upon Dr. Price's report, and that is what the select board voted upon.
So your Mount Healthy defense has two prongs. One is Dr. Price, and the other is the civil service hearing officer who reached in his own conclusion. Is that correct?
That would be part of it, yes, Your Honor.
Do you have anything else to add?
Just one thing, Your Honor. I'd like to distinguish Davignon. I know my brother raised it, if I may. Davignon, my brother relies on this as a case that says that agency decisions are admissible, but doesn't analyze that point. The Davignon says, sure, they could be admissible evidence, but really it's an abuse of discretion review case that this court engaged in, saying that whether or not it was an abuse of the trial court's discretion in that case to admit Mass Labor Relations Commission decision before the jury. And this court said no, reviews for abuse of discretion are reversed only in rare circumstances, that it could be admitted, but that the jury was not likely to put a lot of weight on it because it was an agency finding. This court distinguished 150E and the First Amendment claims at issue in that case, and essentially said, as a matter of abuse of discretion, we're not going to find that here. But Judge O'Toole's decision, his sound decision on the admissibility of the Civil Service Commission's decision in this case, was a sound and correct decision. The commission's decision is not trustworthy. It's unreliable. The plaintiff intends to rely on the conclusions of the commissioner, not the findings. The findings of fact, the underlying base facts of the commission decision, all the testimony, all of the documents, those were largely submitted to Judge O'Toole in the lower court's record. And so he had those facts when he came to the conclusion that neither the town nor the individuals involved in this case violated either the Equal Protection Clause of the 14th Amendment or the First Amendment and retaliated against the appellant.
What about,
thank you.
Counsel, just very quickly, the whole issue of the non-cooperation agreements, you haven't briefed that at all. Is there anything you want to say about that? The public policy argument?
Your Honor, I believe it was briefed in the town brief. So the town submitted a brief and the individuals submitted a brief. The individuals incorporated the town's arguments by reference. The main argument is that the appellant waived that argument in the lower court and failed to raise it. But beyond that, the EEOC case that is cited, I think, breaks down the elements of what is a settlement agreement that violates public policy. And in that case, the very specific agreements that the court said could violate public policy said no cooperation. You can't speak to claimants that were filing charges. You can't file charges yourself. Basically, we're completely silencing the civil rights claimants who had agreed to settlements in that EEOC case that's cited in the papers. Here, the plaintiff first off had the entire record.
I think I've got you. So so it's waiver and distinguishable agreements.
And the main point is the plaintiff never even tried to seek discovery from these three individuals that he's trying to invalidate their settlement agreements.
Understood. Thank you.
Thank you, Your Honor.
Attorney Podolsky, you can mute your device at this time. Attorney Becker, if you could unmute your device and introduce yourself on the record, you have 4 minutes.
May it please the court, John Becker representing Local 950 of the International Association of Firefighters, the union in this case. I'm here on behalf of the union, and we believe that the court below correctly decided that the 1983 action should be dismissed because there was no state action. The union is not a state actor. The 1985 claim should be dismissed because there's no evidence of a conspiracy with the town. As a matter of fact, the court pointed out that there's actually quite an adversarial relationship with the town, even with regard to certain specifics in this case. And finally, the 1981 claim, the lower court correctly found that the statute of limitations bars any allegations prior to December of 2012, which leaves us really with the leave incident and the following issues having to do with the Mr. Alston's eventual loss of his employment, most of which, as you can see from the record, the union was not involved in. The union was really out of the loop in much of this case. Mr. Alston, for whatever reason, chose not to invoke the union's grievance procedures. He did not ask for help from the union. And that's really what distinguishes his case from the comparator cases that he brings up. Those were people who came to the union, who asked the union to help them, who asked the union to file grievances on their behalf, who asked the union to negotiate settlements or negotiate last chance agreements or to represent them in their termination hearings. Mr. Alston did none of that. Instead, he went out, he got his own attorney, and he basically didn't provide the union with information. He didn't let us know when hearings were coming up. He didn't let us know when meetings were happening. He didn't provide us documentation or copies of anything. The town didn't either. So the union was kind of stuck. In a few cases, when the union did find out about incidents that were going on, where this May 14th, this May 2014 meeting, where Mr. Alston received the 2-day suspension, the union reached out to Mr. Alston and said, "Do you want the union there?" And he said yes in that particular case. And the union showed up. And after the meeting was over, the Union President Rosen said to Mr. Alston, "Is there anything you need from us? Is there anything you want us to do?" Mr. Alston said, "I'll call you." He never did. He never asked us to file. So Mr. Alston says he disagreed with the provisions that were set out at that meeting. But where the rubber meets the road when it comes to union activism is after the meeting, when you go up to your union rep and you say, "I want to grieve that. I don't agree with that 2-day suspension," or "I don't agree with those provisions." Mr. Alston never did that. In fact, he served the 2-day suspension. And in fact, one of the provisions which had to do with anger management course, having to go to an anger management program, he did call the union, but he didn't call the union to complain about the provision. He called the union to find out if he had to pay the co-pays and the deductibles for that course, or whether that was something that the town would have to pay. And the union actually did some research on that and got back to him, and ultimately union council decided that there was no precedent for requiring the town to pay, and that he would have to pay. But
Council, let me interrupt for a moment. One thing there are a lot of things I'm not clear about yet, but one thing is your brother seems to want us to hold the union directly responsible for every statement that appears on what he refers to as the union blog, which I take it as a Facebook blog?
That's right, Your Honor. It's actually a separate blog from Facebook, but
Okay.
it
And
is
do you agree that every statement there is the union's responsibility? I mean, how does that blog work?
I do not agree. No, Your Honor. That blog is accessible to every union member, and that every union member has the right to put up anything they want to on that blog. What we found in this case.
Time.
May I continue?
Finish. Yes.
What we found in this case was that Mr. Alston saw the Faceless Coward blog from Joe Canny, and he went to the union president, Mr. Fay, and complained about it, and Mr. Fay immediately took it down. So our position is the union, when it was alerted to problems with blog posts, it took action as required to take offensive posts off, but that it did not have a system for vetting things before they went up. But if somebody had a complaint, they would take care of it.
Okay, thank you. That clarifies that for me.
I see that my time is up. If there are no other questions, I'll rely on my brief.
Thank you.
Thank you, Your Honors.
Thank you, Attorney Becker. You can mute. Attorney Schatz, please introduce yourself on the record, and you have 2 minutes.
Thank you. Good morning, and may it please the court. My name is Naomi Schatz, representing appellee Stanley Spiegel. With me on our briefs are Martin Rosenthal and David Duncan. We believe the lower court correctly dismissed Mr. Alston's claims against Mr. Spiegel. Mr. Spiegel has not come up so far in this argument, precisely because the allegations against him are so minimal and attenuated from the crux of Mr. Alston's claims. The only allegation against Spiegel before this court is that on a single occasion, Mr. Spiegel told an unidentified third party that he had access to Mr. Alston's personnel file and that she would not support Mr. Alston if she knew the, quote, real story contained in that file. Only 2 of the claims that Mr. Alston originally brought against Mr. Spiegel are at issue on this appeal. He has only argued that his First Amendment retaliation claim stated a claim and should not have been dismissed, and that his claim that Mr. Spiegel participated in a conspiracy to deprive Mr. Alston of equal protection stated a claim that should not have been dismissed. In dismissing Mr. Alston's First Amendment complaint, the magistrate judge correctly noted that Mr. Spiegel's brief comment was, quote, innocuous. Moreover, Mr. Alston did not plead that this comment had any impact whatsoever on him, much less an impact that rises to the level of a civil rights violation under any of the statutes Mr. Alston pleaded against Mr. Spiegel. In our briefing, we have pointed to 6 or 7 deficiencies in the complaint, each of which is fatal to Alston's claims against Spiegel. But this court need go no further than the question of qualified immunity to uphold the district court's decision. Mr. Alston has waived any argument that Mr. Spiegel is not entitled to qualified immunity by failing to address it in his brief. That in and of itself should end these claims against Mr. Spiegel. But in addition, the fact that Mr. Alston admits to this court in the companion sanctions case number 201435 that his argument for liability requires this court to extend existing case law is an admission that Mr. Spiegel's actions did not violate any existing clearly established case law. I believe my time is up. I don't know if there are any questions from the court.
No, thank you.
Thank you.
Thank you, Attorney Schatz. You can mute your device at this time. Attorney Ames, for rebuttal, please reintroduce yourself for the record. Attorney Ames.
Sorry. Brooks Ames for Gerald Alston. The one point I'd like to leave on has to do with why was Mr. Alston terminated? And the argument that I heard from the town is he was terminated for failing to comply with conditions. But it has to be clear that Mr. Alston was not terminated because he violated some drug policy, for example, of the town of Brookline. The town of Brookline does not terminate for use of drugs. There's evidence on the record that when Mr. Alston was brought before a disciplinary hearing internal to the town, they had of drugs. They did not terminate him. he received a warning. So there was this is not a termination for drug use. It's not a termination for making threatening statements. Mr. Alston was not terminated for making threatening statements. He got a 2-day suspension for that. So the issue really boils down to, why did Mr. Alston have to see a psychiatrist and take anger management in order to return to work? The reason, according to the town, was that Mr. Alston was failing to cope with this backlash and the aftermath and the continuing retaliation by Lieutenant Pender, who was promoted all the way up to interim deputy chief of the department, that it was Mr. Alston's responsibility to accommodate and deal with that environment. The important finding, the key finding of the Civil Service Commission was that the town was responsible for that environment, and effectively it couldn't poison the workplace against firefighter Alston and then fire him because he couldn't tolerate that environment. So the true reason that he was terminated was the misconduct of the town, the acts and omissions of the town that made the workplace intolerable for him to return to. And the hiding behind the expert's report and the hiding behind an outside hearing officer doesn't work. And it was exposed in the 10-day in front of the commission because there were many facts that came out that had not been provided to the town of Brookline, that were in the sole custody of the town of Brookline. Those facts were not provided to the expert, were not provided to the outside hearing officer. And Mr. Alston didn't have possession of them because discovery hadn't begun in this case. So it was a misleading
Thank
picture.
you, Mr. Ames. Unless my colleagues have some questions, your time is up.
Thank you, Your Honors.
Thank you.
That concludes the argument in this case.
Thank you, Your Honor.
I'll call the case, Mr. Ames. The next case today is Brooks A. Ames versus Stanley Spiegel, appeal number 20-1435. Mr. Ames, please introduce yourself on the record.
May it please the court, Brooks Ames, representing myself. It's clear that sanctions cannot rest only on a claim being dismissed under a 12b6 standard. There must be something more that warrants a sanction. In this case, the district court actually reversed the initial 12b6 dismissal of the magistrate on the claim against Spiegel. And the district court held that because Alston had been allowed to replead other claims that had been dismissed, it was only fair that he be allowed to replead his claims against Spiegel.
Yeah, I don't really consider that a reversal. He vacated it, gave you an opportunity to replead if you wanted. The district court never intimated that that original dismissal was wrong or incorrect.
Okay, Your Honor, I won't dispute that. My only point was that there was a opportunity for the district court to weigh in on the viability of that claim.
Well,
and
the district court gave you a chance to make a better showing than you had made.
It's true that the district court...
Nothing wrong with that. Didn't force you to attempt to do it.
I appreciate that, Your Honor, that's true. But the district court, there was a pending motion for sanctions at that point already, and the district court didn't make a commentary as to the viability of the claim, whether it was frivolous or the like.
Had that motion for sanctions been ruled on by the magistrate judge?
No, the magistrate
judge...
it
was not before the district court. The magistrate judge hadn't acted on it.
That, again, Your Honor, you're correct. My point remains that there was not, from my perspective, a signal from the district court that this was a frivolous claim in the courts.
What more signal did you need? You had the magistrate judge, all right, dismiss the claim, and you knew there was a motion for sanctions pending before the magistrate judge. So you knew that first of all, Rule 11 puts you on notice of your obligations, but you knew that those obligations were in play. And if you had by any chance overlooked that, you also had received a notification from opposing counsel, had you not? That
yes,
I certainly your Rule 11 obligations.
I certainly had notice from opposing counsel. My point is that a bare 12b6 dismissal, which is all I regarded the magistrate to be doing there, was dismissing the case on the grounds that it did not state a claim. It is not the same thing as saying that it's a frivolous claim. In objecting, I did object to the magistrate's dismissal of the claim, and I brought up the case of Ray versus Ropes and Gray. And the district court didn't comment on that case, but it was not a case that was ever distinguished by the court. And my view was
not
that
hard
Ray,
to distinguish, is it? Didn't Ray involve a suit by a former attorney against his quondam employer?
Yes, it was. Yes,
Mr. Spiegel was not your client's employer. There was no relationship between
Spiegel had access. Well, in my view, the holding of Ray, which was that threatening to disclose damaging information or disclosing damaging information could deter someone from making a claim. And in my view is that principle applied to Mr. Spiegel, because he was in a position to have access to damaging information about Mr. Alston. He claimed to a third party that he had access to Mr. Alston's personnel file, and that file contained damaging information. So I viewed that as under the principle of Ray. since Ray had not been distinguished by the magistrate judge, and it was in my brief to the magistrate judge, I viewed that as a continuing to be a viable theory, and I pursued it.
Is Ray the best authority you have? In other words, if we were to conclude that your proposed amended complaint against Spiegel does not constitute a valid extension of Ray, do you lose? Or do you have some authority that's better than Ray?
No, if your honors conclude that there's no reasonable possible way that Ray could apply to this case, then I would lose. But
well, Ray couldn't apply because Spiegel's not the employer, and what you characterize as the threat was not made to your client. It was as I understand it from the record, it was a statement made. We don't even know to whom, but we know that it was made to some third person.
Well, I didn't take the Ray holding to be dependent on it being the employer.
I didn't ask you what you took the Ray. All that I'm saying is that this case is factually distinguishable from Ray. So the question, at least in my mind, is whether the legal rationale of Ray can plausibly be extended to justify the assertion of this claim in the face of an earlier dismissal and in the face of your receipt of a Rule 11 notice letter.
I don't.
But I just want to be sure that you don't have some other precedent that you're relying on that is stronger for you than Ray.
I don't have a precedent that's stronger than Ray. The only other authority I'd point to is the fact that the district court, approximately a year after dismissing Spiegel, concluded that 10 of these, or maybe 8 of these individual defendants, that there was sufficient plausible allegations that they were engaged in a conspiracy, including allegations that they had distributed negative information about Mr. Alston. And
what does that have to do with Spiegel?
Well, Mr. Spiegel was involved in those allegations. One of the allegations.
Did the district court make a finding with respect to Spiegel? That's what you're saying?
No, the magistrate judge made a ruling on the motion to dismiss. And in that ruling, the magistrate judge concluded that among the evidence that would support, part of the evidence that would support a conspiracy was that there were letters circulated, negative letters, about Mr. Alston by Select Board member Nancy Daly, and that was done. The fact is that we allege that was done in concert with Mr. Spiegel. And then after that happened, Mr. Spiegel engaged in this conduct in the Select Board's hearing room, in which he intimated that he had negative information about Mr. Alston. So I viewed that as part, the fact that the magistrate judge had concluded a valid conspiracy had been pled, and that it included multiple members of the town government, that made it more plausible that Mr. Spiegel, who's also part of the town government, just not in the same position. He's not a Select Board member. He's a member of the advisory committee. He has a different position. He has a different role. But it doesn't change the fact that he has this information and he's communicating it. He's not communicating it directly to Mr. Alston, but when he communicates it to a supporter of Mr. Alston, that's how you do a smear campaign. That's how you do a whisper campaign. And that's what I viewed was going on, that the Select Board, using proxies like Mr. Spiegel, were spreading information that would cause firefighter Alston to have pause about whether he wanted to continue to speak out and take on the town of Brookline on this volatile topic. And I'll just remind you that it was just a week after firefighter Alston had gone public with his grievance against the Select Board, a meeting that was publicized in the Boston Globe and the local paper. It was only a week later that Mr. Spiegel entered the picture, and was, in my view, spreading negative information about Mr. Alston for the purpose of dissuading him from continuing to speak out, and doing so in concert with other members of the town government.
What can you point to anything then in your refiled claims that amount to more than what the magistrate judge called cosmetic changes? Is there anything in your refiled claims that adds meat to the sandwich?
Your Honor, I'm not going to challenge that. It's obviously there are differences, but I'm not going to challenge that. And if I can just respond to that point, though, if the complaint is refiled, or let me put it a different way, if it's not refiled, if it's my view, perhaps wrongly, that the initial complaint had merit and the magistrate judge got it wrong because I have a different view of Ray than she does, then my client can't pursue that claim unless I refile it. Otherwise, we're out. We don't have a chance of ever seeing whether that claim holds muster and stands up to review. Now, it may be the case I'm feeling the signal that it's not a claim that the First Circuit has a lot of sympathy for, but that doesn't mean that I'm not entitled to refile it as long as I have a plausible basis in the law or the extension of the law to do so.
And that claim had been dismissed the magistrate judge had recommended its dismissal. If you didn't ask the district court for leave to replead, the district court, it would have been affirmed, and you would have had eventually an end of case appeal from that dismissal. No one forced you to replead that claim.
I'm not sure about that. I thought that if you didn't object to a dismissal by a magistrate,
you had to object, but you did not have to accept the district court's invitation to allow you to replead it. You could have said to the district court, we're going to stand on that claim. And then the district court would have had to rule up and down, either vacate what the magistrate had done or affirm the dismissal, at which time at the end of the case you'd have an appeal.
I'm afraid I'm not sure I follow that. The district court, I objected. The district court made a ruling that it seemed to me put me in a position where I had no choice but to refile, or else I would be waiving the appeal.
I'm not going to argue the point with you, counsel.
Are there any further questions? No. Okay. Thank you, Mr. Ames.
Mr. Ames, please mute your device at this time. And Attorney Schatz, if you could please unmute your device and introduce yourself on the record. You have 8 minutes.
Thank you. My name is Naomi Schatz, again, representing defendant Stanley Spiegel. And I'm here with my co-counsel, Martin Rosenthal, who will be taking the other 2 minutes of our time. The district court's decision to award sanctions against Attorney Ames was well within its discretion, and Attorney Ames has made no showing that that discretion was abused in this case. As this court stated in Navarro Ayala versus Nunez, appellate review of an order under Rule 11 is deferential. The abuse of discretion standard requires that a sanctions decision only be overturned if it's based on mistake of law or clearly erroneous finding of fact. The appellant does not argue that there's any erroneous finding of fact, and for the reasons we discussed and briefed in the companion merits case that we just argued, the district court did not make a mistake of law. I do want to address two small points my brother just made, correct something he said. He claims that there was an allegation in the complaint that Mr. Spiegel acted in concert with Nancy Daly with regard to the circulation of some published letters to the editor. That is not an allegation that was made in the second amended complaint, which is the complaint that is at issue in this case relevant to Mr. Spiegel. And I know you just had a discussion also with my brother about the question of whether he had to refile his claims in order to preserve them. To be clear, that is not something that Mr. Ames ever alleged he was doing in the district court. He never made clear to the district court that he was filing solely because he felt he had to in order to refile. While the First Circuit hasn't addressed this this question of when refiling is necessary directly on point. Most circuits hold that refiling is not necessary under these circumstances. So that is not what he was doing when he refiled. He made, as you noted, a couple of cosmetic changes and continued to press his claim as a valid claim, despite changing none of the substantive allegations. Attorney Ames' argument in this case that his claims were not frivolous because he argued for an extension of Ray versus Ropes and Gray really underscores exactly how frivolous they were. Because first, he never made that argument to the trial court. In the trial court, he argued that existing law addressed his client's claims. He has only now on appeal come up with this argument that an extension of Ray would be necessary to cover those claims. But that is not what the trial court was looking at in deciding the merits of this case or these sanctions. And second of all, as I think I alluded to in our merits argument, if the case would have to be extended to cover Mr. Alston's claims against Mr. Spiegel, and Mr. Alston has pled that Mr. Spiegel was a public official who is entitled to qualified immunity, then that argument is a concession that there was not clearly established law, and therefore that Mr. Alston cannot overcome Mr. Spiegel's qualified immunity. The purpose of Rule 11 sanctions is to deter attorneys from filing frivolous or meritless claims, and the district court would have been within its discretion to award sanctions at the time it dismissed the first amended complaint, which the magistrate detailed was entirely meritless against Spiegel. And the district court adopted in full her reasoning. The sole change the district court made was to give Alston a chance to cure the defects and plead new plausible claims against Spiegel.
Counsel, I'm a little leery of relying on waiver. Did he raise the Ray case before the district court?
He did, and the magistrate addressed it in detail in her second report and recommendation, arguing to finding that it did not give him grounds to make these claims against Spiegel.
And you had the chance to argue that Ray did not apply and no extension of Ray would have applied. And if it was an extension, all that did was support your qualified immunity defense, right?
Well, he never argued any argument about extending Ray, and so no.
That's the point I'm getting at. If he raises Ray, does he really have to specify either it applies directly or an extension of it? And if he doesn't, we hold he has waived the argument. I'm not sure that you need that in order to achieve the objective you want.
I would agree with that as to the merits of the case. I think my only point was that in his briefing, he relies on the portion of Rule 11 that states that a claim is not frivolous if it is grounded in, a plausible reading of the law or argument for modification or extension of the law. And the court below had no opportunity to assess whether there was any plausible modification or extension because that wasn't raised before it.
But I assume you below raised that exception to Rule 11 does not apply here. Even if he didn't argue, it does apply.
I would have to go back and look at exactly how we briefed it below, but I believe we argued that because he was I don't know if we specifically addressed that exception because it wasn't raised here.
All right, thank you.
As to my final point was just as to the discretion to award the sanctions. The court could have done it when they dismissed the first amended complaint because those claims were entirely baseless and not predicate, no reasonable attorney as required by Rule 11 would have thought that the facts as alleged met any of the necessary legal elements of the claims being pursued.
Again, I'd be reluctant to rest on that. To me, your stronger argument is gee, the judge gave him another chance and he decided to take the chance rather than force the issue and take an appeal. And when he took the chance, he didn't add anything new. He said exactly what he said before, right? Isn't that your basic argument?
That is what the magistrate, that is why the magistrate decided to impose sanctions, and we agree with that decision.
All right.
If there are no further questions, I will turn things over to Attorney Rosenthal.
Okay. Thank you.
Thank you.
Thank you, Attorney Schatz. You can mute your device at this time. Attorney Rosenthal, please unmute your device and introduce yourself on the record.
Yes. Am I on?
Yes.
Okay, thank you. Sorry about that. Yeah, may it please the court, Martin Rosenthal, also for Mr. Spiegel. After 48 years, I wish I could say I'm finally happy to be here, but I won't. Without repeating Naomi's overview or our briefs, including the Joe Welsh quote, I just want to highlight 4 gorillas in the room. I happen to know a thing or two about Brookline, about deterrence, and about legal ethics. This case is really a poster child for sanctions. It flouts not just Rule 11, but other rules too. Mr. Spiegel's now 85, has been a 5'6" giant in town government, 39 years an elected legislator, 32 on the advisory committee, the hardest committee in town. He's now had 5 pretty hellish years, so far undemnified by the town, and it's basically no good deeds shall go unpunished. Besides 19th century stuff, the allegations started in 2010 on this whole case, and we're now down to one alleged 2014 spontaneous conversation with an unnamed person. An obvious inference from reading that complaint is less than a 3-minute conversation out of, by my calculations, about 3 million minutes since 2010. He's also a poster child for qualified immunity, whose goal was protecting public service. And there's no better poster child for that than Mr. Spiegel. In Brookline, this matter's history has been for a decade hotly debated, but here, fortunately, what matters is just the sole allegation against Mr. Spiegel and the law. As was stated in Parker v. Landry, moral indignation is not enough to hold officials liable for every abuse that occurs there in a prison, and especially where, if here, like here, if there was any abuse, it's only by someone else. So we say there ought to be a law. Thankfully, there are several laws, and please affirm. And by the way, the racial animus would be a joke if it weren't for the nightmare that this case is imposed on Mr. Spiegel. He has no racial animus and none was alleged. Thank you.
Thank you. Any further questions from anyone?
No.
No. Thank you.
Thank you, counsel. At this time, that concludes the arguments in this case. The next case today is Victim Rights Law Center et al. Versus Foundation for Individual Rights and Education et al. Appeal number 20-1748. Attorney Baltus, please introduce yourself on the record.
Thank you. May it please the court, Alexa Baltus on behalf of proposed interveners. Your Honor, may I reserve 2 minutes for rebuttal?
Yes.
Thank you. In one conclusory sentence, without briefing or even positions from the existing parties, and with knowledge that proposed interveners had been granted intervention in a parallel case, the district court denied proposed interveners 2 distinct claims for intervention with a bare recitation of a single 24A intervention factor.
Counsel, that's not I wouldn't lead with that argument. Either the district court is right or the district court is wrong under an abuse of discretion standard. Can you get to the merits and not complain about lack of reasoning?
Sure, the district court is wrong on those two options, Your Honor. Turning first to intervention as of right, proposed intervener's entitlement to intervention as of right turns on one question: whether the Department of Education, with its legal and political obligation to weigh competing interests, its own interest in preserving flexibility for future decision-making, and its eagerness to accept a procedural victory in this case, may inadequately represent proposed interveners, who have a single-minded focus on ensuring the broadest possible free speech and due process protection on college campuses, an interest in curtailing the flexibility of the Department of Education by demonstrating that the final rule is consistent with the constitutional floor, and multiple interests in avoiding a procedural ruling on this.
Counsel, when you cut through everything you just said, what I basically come away with is the proposition that this regulation or these regulations are being defended by the department on a ground that your client does not think is the best ground to defend them on, or the ground that will provide the most enduring or far-reaching relief. And your client would like to be in the case to assert its own theory with respect to the validity or constitutionality of the regulations. And my immediate reaction is that we wrestled with this question, or a virtually identical question, 7 or 8 years ago in the Massachusetts Package Store Association case, and held that that didn't make any difference, that the government agency was a proper representative, and the private party, though it had a separate theory as to the status of the regulations, could assert that theory by way of an amicus brief. Why isn't that decision of precedential force with respect to this case?
Well, a few reasons, Your Honor. First of all, in that case, this court said that the only difference was this different argument, this additional constitutional argument. Of course, that's not true in our case. We also have our argument directly subverts the institutional interests of the Department of Education, which is what this court said distinguished different interests in sort of the motivational sense and the institutional sense in Patch. Also, in Massachusetts Food Association, it's important to note that the proposed interveners were allowed to raise their arguments in an amicus brief, which of course the district court declined to consider. Here, our claims are directly relevant to the issues presented and the additional constitutional question.
So my take on it is you want to be allowed to intervene as of right so you can convince the district court to abandon the rule of constitutional avoidance and instead reach out and decide a constitutional issue which the agency has preferred not to advance. Why would any court of appeals ever do any such thing?
Right. I respectfully disagree with that characterization. I think we are actually imploring the district court to take a posture of constitutional avoidance. Our constitutional arguments, assuming that they are true for the purposes of intervention, or assuming that they're accurate and right for the purposes of intervention, they could change the statutory interpretation of the plaintiff's APA challenges. They say that
no, you want to bind any successor administrations to your constitutional view. And you're afraid with the change in administration coming up that possibly the agency will exercise its rulemaking authority in a different way. And you want to stop that from happening. Again, I know of no case that says you are entitled to intervention as of right on that basis. And going beyond that, I can't imagine, well, we don't have to face the issue in this case of whether permissive intervention would have been appropriate, but I have to tell you, I doubt under those circumstances it would have been appropriate.
Well, just to clarify our position, it is not that the department has no discretion to depart from this rule. It is that the rule as it stands right now is commensurate with the constitutional floor. Of course.
No, yes, you're saying it's constitutionally compelled, and that any such ruling would presumably be binding on future administrations. Isn't that correct?
That's correct, and I think that demonstrates the inadequacy of the department's representation. They obviously have institutional reasons not to tie their hands, but the Constitution does, and it should be addressed in this case.
Well, there's sort of basic Article 3 issues about not reaching out to bind the other two branches of government with unnecessary judicial rulings on constitutional issues. So I think your theories are actually quite dangerous.
Well, Your Honor, our theory is twofold. One, it has the constitutional element you're talking about, but also in the constitutional avoidance sense, a district court interpreting Title IX or the Clery Act or any of the other things that plaintiffs invoke could not read those statutes to require a more speech restrictive, more due process restrictive rule under our theory. So it is not an additional, not simply an additional argument. It is also relevant to the statutory question in this case.
All right. I understand you presented your intervention as of right. Do you want to say anything about permissive intervention?
Yes, I would, Your Honor. I know you noted that at the outset that you're not really moved by the one sentence order from the district court, but it really is important to know that it came after zero briefing, not even positions from the parties, and after the district court and the District of Columbia had granted permissive intervention on these exact set of circumstances. There is no way to review or respect discretion that we don't even know was exercised. The court never.
But isn't that foregone? Our recent T-Mobile decision makes it very clear that our review for abuse of discretion goes forward even in the face of a docket entry or other order that is unelucidating on its face, that we still give the district court the margin of its discretion, and that the court isn't required to spell out the reasoning behind such a denial.
That's right, Your Honor. But in T-Mobile, it said it looked to the rest of the record to fill in what wasn't in the order itself. There is no record here. There's no positions, there's no arguments, there's no opposition. The T-Mobile order said it considered. Time. If I may.
I don't understand. There is the complaint.
Yeah.
There is your theory of intervention. What do you mean there's nothing in the record?
Nothing in the record that would oppose a permissive intervention. There's no arguments that.
Well, there are certainly briefs that oppose it.
There were not at the time.
No, but there are now, and it doesn't say we look to the record at the time the district court rules. We look to the record, and what's of record are the arguments of the parties, the complaint.
Right, but you look to the record to fill in what the district court must have been thinking. I think that's the language used in Caterino. We don't know what the district court must have been thinking because there was no record at that time. And it is our position that you do look to the record at the time the motion was filed. That's what the district court was considering, and that's when he exercised his discretion.
Okay, thank you, counsel.
Thank you.
At this time, Attorney Baltus, you should mute your device. Attorney Chen, if you could unmute your device and introduce yourself on the record.
Good morning, Your Honors. May it please the court, Michael Chen for the plaintiffs. The movements in this case cannot distinguish themselves from the movements in cases like Massachusetts Food Association and T-Mobile, or the countless other groups that have interests in cases of great public importance. And district courts are not required to grant party status to all groups in this position. And so the district court here did not abuse its discretion in denying the motion to intervene. I'll address the intervention as of right issues before turning to permissive intervention. On intervention as of right, Judge Selya is absolutely right that this is not the first time this court has confronted a prospective intervener that wants to jump in and supplement the arguments made in defense of an existing party's position. Massachusetts Food Association is just one of several cases that's squarely on point here. And I heard my friend from the other side this morning attempt to distinguish Massachusetts Food Association in a couple of ways that weren't raised in the brief, so I'd like to address those now. So my friend on the other side said that in Massachusetts Food Association, there wasn't a divergence of interest because here the movements would want to subvert the department's interests. But I think actually the same argument was raised in the briefs in Massachusetts Food Association. The prospective intervener said there that the government didn't have an interest in making the constitutional argument that the movements wanted to make, and this court was unmoved. And then also, even if you wanted to look beyond Massachusetts Food Association, I think certainly what my friend on the other side said about this case could be said of the Maine case, where you had environmental groups arguing to limit the government's ability to the government's flexibility in environmental regulation because the groups there had a single-minded interest in greater environmental protection. My friend on the other side also said something about the ability to file an amicus brief, and I think that point squarely cuts in our favor. Nowhere in the briefing that the movement submitted in this court, or I think this morning, did the movements even attempt to explain why they couldn't just offer their constitutional theory as amici. And that alone is reason for the district court to deny intervention as of right and to find adequate representation under cases like Massachusetts.
Counsel, I may have misunderstood, but I understood counsel for the appellant to say that the district court had refused to permit the filing of an amicus brief?
Not at all, Your Honor. In fact,
okay, I want to clarify that.
That is what she left us with. You're saying that's not accurate.
That was a weak argument.
It's not accurate, Your Honor. The district court's order denying intervention in the very order being appealed from says that the movements are invited to file an amicus brief. And so that is exactly the rationale that this court relied on in Massachusetts Food Association in affirming the denial of intervention as of right. And again, that's an argument that we made in our brief and that the district court stated.
Oh, no. Intervention as of right does not turn on permission to file an amicus brief. That would be a terrible rule for any court to adopt. It may be a plus factor here in favor of affirmance, but you don't seriously want to argue that it turns on the question of filing an amicus brief.
Your Honor, I want to be precise about what we're saying. All we're saying is exactly what this court said in Massachusetts Food Association, which is that when a prospective intervener has a supplemental argument that they want to make, and they can also make that argument just as well in an amicus brief, that does not satisfy the prospective intervener's burden to establish inadequate representation. That's what this court said in Massachusetts Food Association. That's the position we're asserting here. But even if Your Honor wanted to look beyond that issue, I think there are several other reasons why the district court was entitled to find adequate representation here. And another reason is the one that Your Honor alluded to in your questions in the first half of this argument about the nature of the constitutional argument that the movements are trying to make here. So this court said in cases like Maine and Students for Fair Admissions that another thing the court looks to when you have a movement trying to make these sorts of supplemental arguments is whether those supplemental arguments are obviously necessary to the shared result. And here, one of the many reasons that the movement's constitutional theory is not obviously necessary to the result is that it is sort of a second level argument that principles of judicial restraint and constitutional avoidance would counsel against reaching before the statutory arguments that are at the centerpiece of the plaintiff's claims and that the government is already redressing. Those are the more direct responses to the plaintiff's claims, and they're already being made by the existing party in this case. So for
5 minutes remaining.
For those reasons, I think the district court's denial of intervention as of right on the adequacy prong was squarely within what this court has already held in Massachusetts Food Association and Maine and the other cases. And I also want to be clear about the standard of review, which several of the questions touched on this morning. And under the abuse of discretion standard of review that applies here, the burden is on the movements to show that the district court only had one permissible option here, that in making the judgment call about adequacy, it had to find inadequate representation, contrary to what this court held in analogous cases. And forcing district courts to grant intervention in cases like this would not only contradict this court's precedent, but would also give an easy recipe to other groups that might otherwise just participate as amici to insert themselves as mandatory parties to the litigation. I'm happy to answer other questions.
Yeah, I'll tell you the concern I have, not in this case. I did have it in the Maine case. It's sort of a hypothetical concern, but sometimes, especially on these issues of national importance, a understaffed, underfunded state attorney general's office is left to defend a major national case. And sometimes they say, gosh, the arguments aren't inconsistent. We do think we can do an adequate job in terms of theory, but we're just outgunned here by the array of counsel on the other side. So we don't think they can intervene as of right, but we're asking you, court, let them in as permissive interveners, because frankly, we need the help. They're on the same side of the issue that we are. So I just, on permissive intervention, as I said, this case doesn't really raise that concern. But do you think that's something that a district court can consider on permissive intervention?
This court has held, Your Honor, that the permissive intervention standard is quite broad, and a district court can consider a very wide array of factors. So I think in an appropriate case, a district court could take that into account. But I think it is very important to note that that concern, as I think Your Honor noted, is not present in this case. The department has mounted a vigorous defense of this rule. It has filed many extensive briefing. It sent a senior Department of Justice lawyer to argue the case at trial. And so I don't think there's any claim that could be made, and certainly the movements haven't made it. The department is not vigorously defending the rule in this case. And so I think even on the permissive intervention issue, we made arguments to the district court that it should deny permissive intervention here. But as I was saying about the standard of review, it's not our burden to show that the district court was required to deny permissive intervention here.
I'm never worried about the Department of Justice being undermanned with or underwomaned with lawyers and not having adequate resources. But very frequently out here in the hinterlands of the circuits, it is the state attorney general's office which gets landed with defending these lawsuits. And the Justice Department frequently decides that they're not going to play a role in the case. So it's a hypothetical concern, not really raised in this case, but I thought it was worth mentioning.
Absolutely, Your Honor. And I think it absolutely makes sense if Your Honor was concerned about that the solution to that concern is the very broad discretion that the district court has under the permissive intervention standard. But in this case, that broad discretion cuts squarely in our favor, in favor of affirming the district court, because the district court's decision here was squarely within its discretion, as the movements don't even seriously contest. So the movements on permissive intervention aren't aren't disputing that the conclusion that the district court drew denying permissive intervention was within its discretion on this record, even the record that was before the district court at the time. They just want a remand for the district court to give more reasons. But the district court already in its order gave 2 reasons, the very 2 reasons that this court relied on in Massachusetts Food Association in affirming the denial of permissive intervention, adequacy of representation, and the ability to file amicus briefs. And so there's no need.
That's time.
There's no need to remand to the district court on either issue.
All right. Any further questions?
Briefly, Attorney Chen, real quickly, you focused your argument on adequacy of representation. Should I assume your position is, I'm getting you back, by the way, to intervention as of right. Should I assume that sufficiency and properly situated, sufficiency of interest and properly situated are satisfied in this case, and it all comes down to adequacy of representation?
For purposes of this appeal, I'm happy for the court to assume that, because that's all the appellants have asked the court to decide. The appellants recognize that even if they prevail on this issue, the case goes back to the district court for the district court to apply the other intervention factors. They say that in their opening brief, and we say that in our response brief. So I'm happy for the district court just to focus on the adequacy issue. And I said that's squarely within Massachusetts Food Association, Maine, and the other cases.
Thank you very much. Sorry to prolong.
Okay, thank you, counsel.
Thank you.
Attorney Chen, you can mute your device at this time. And Attorney Baltus, if you could reintroduce yourself, you have 2 minutes.
Thank you, Alexa Baltus, for proposed interveners. I have just 3 quick points to make on rebuttal, Your Honors. First, I wanted to clarify, in case I misspoke, we were permitted to file an amicus brief. That was part of the order. My point was that that didn't sufficiently protect our interests. We couldn't have raised new arguments in that amicus brief under this court's case law, and the court wouldn't have been required to consider them in any event. It also wouldn't have given us the right to participate on appeal or in oral argument, and all of the other factors that go along with being a party. Second, while we maintain that the department's representation is inadequate, if this court disagrees, we respectfully request that the court note in its opinion, as it routinely does, that proposed interveners would have the opportunity to renew their motion if the department's representation ever becomes inadequate.
Why? I'm sorry. I know we've done it before, but why would we do that?
Well, Your Honor, I think if the department
that suggests we're dealing with some future case which we don't have in front of us.
That's right, in some sense, but it is this case in the sense that that's part of the whole theory about maintaining flexibility to maybe not defend this rule in the future. This court has noted the ability to renew a motion in Caterino, in Mosbacher, in Daggett.
But that argues against you. We've noted that, and the district courts are aware that we've said that repeatedly, so we don't have to say it again. They get it.
Okay, well, we would encourage you to do so, just so it's clear in that they do know. And then finally, my third point, Your Honors, is just to note our strong affirmative case for permissive intervention that may have gotten lost in all of this. We're repeat players in the First Amendment and due process fields. We'd be able to assist the court. There's no possible delay from our participation, and it would limit spin-off litigation going forward.
Okay.
Thank you.
We got the point. Thank you very much. Okay. Next case.
Yes, Judge. That concludes arguments in this case. Attorney Ball. The next case today is Rhonda Ovist versus Unum Life Insurance Company of America et al. Appeal number 201464. Attorney Feigenbaum, you may please introduce yourself on the record.
Good afternoon again. May it please the court, Jonathan Feigenbaum for Rhonda Ovist. May I reserve 2 minutes of my time for rebuttal, Your Honor?
Yes, you may.
Thank you. In this case, Unum agrees that Professor Ovist was diagnosed with fibromyalgia, and Unum conceded she was occupationally impaired. In fact, in the final adverse benefit determination letter, Unum wrote, quote, "We do not refute that Ms. Ovist is unable to work." That's at page 378 of the record. So,
counsel,
yes.
We've read the briefs. We know the issues. Move on.
I'd like to begin my arguments focusing on why this circuit should follow Weisenkamp and Chronister, and time permitting, address the burden shifting arguments. So this court should resolve the case in favor of Professor Ovist and follow both Weisenkamp and Chronister. Here's why. In both of those cases, Unum was the defendant. In both of those cases, Unum had discretion to interpret the benefit plan. In both of those cases, the disabling illness was fibromyalgia. In both of those cases, the plans contained a self-reported symptoms limitation clause that is identical. In both of those cases, the 7th Circuit and 8th Circuit held that fibromyalgia is verifiable by clinical examination, standardly accepted in the practice of medicine. And that exam is the trigger point testing. In both of the cases, the plan participants proved functional loss. So did Professor Ovist. In addition to providing what I would call copious medical history as to her functional limitations, Professor Ovist delivered to Unum with her appeal cardiopulmonary exercise testing, CPET testing. And that testing will say documented with data her functional limitations. So the central issue that this court needs to resolve is whether the self-reported symptoms clause relates to diagnosis or to symptoms. In both Weisenkamp and Chronister, the 7th and 8th Circuit held that the clause applies to diagnosis and not disabling symptoms because of the way the clause is written, and principally because fibromyalgia is diagnosed by trigger point testing, and this qualifies as a clinical examination standardly accepted in the practice of medicine. So to avoid the holding of Weisenkamp in this case, Unum is raising 2 inconsistent arguments for the most part for the first time on appeal. First, Unum in its brief concedes the case is about functional loss, and this follows along the First Circuit cases beginning with Boardman, which essentially holds that for certain conditions, medical conditions, and a plan fiduciary cannot demand what we'll call a laboratory type testing, but can demand objective proof of loss of functionality. So what I'd say is so far so good. But then when Unum has to address the 2-day CPET testing that Professor Ovist provided that documented her functional losses, Unum really changes its tune. At page 34 of its brief, Unum wrote, quote, "Not one of Ms. Ovist's treating physicians cited the CPET as an objective evidence of her diagnoses." So what I take from that is Unum is saying the way the clause reads is that it entails diagnosis and it also entails functional loss. And as the 7th and 8th Circuit held, the way the clause needs to be read in connection with at least a fibromyalgia-based claim, it only goes to diagnosis. So if the impairing symptoms are pain, the claim is outside the clause. Other points I'd like to make relating to the CPET test is in some sense, it does provide objective verification of the diagnosis. It's not directly on point like a laboratory test, but it is some type of data point providing additional information beyond what the patient reports or what the physicians observe or any of the other healthcare providers. So I'm suggesting to the court that Unum's interpretation was not reasonable. It's an abuse of discretion. And one way to measure an abuse of discretion, right, can be substantive or procedural. Interpreting a plan in different ways, depending on the facts, particularly when you have circuit courts going against the preferred reasoning for one of the parties, is indicative of an abuse of discretion. The Chronister was decided in 2006. Weizenkamp in 2011. If Unum didn't like the way that the courts were interpreting the plan, Unum could have amended the plan, for example, the one that was sold to Rollins College. And I would say to this date, from litigating other Unum cases, this language appears in the plans in the same way and has never been amended. So I'd say Unum has been on notice as to what the correct interpretation of that particular language means. And the Seventh Circuit was particularly troubled about Unum's purported interpretation because literally read, and the circuit reached the conclusion that the language didn't mean that, was that any pain condition, including things that are just obviously painful and debilitating, would allow Unum to impose this limitation and cut off benefits after 24 months. So the Seventh Circuit rejected that position, which actually Unum admitted to in oral argument. It's documented in the court's opinion. So moving to the second issue, Your Honors, of which the Department of Labor will speak more about, I'm suggesting that this court should tackle the issue as to the burden shifting. And I propose the following. In an ERISA plan, in an ERISA litigation where the plan has an exclusion or limitation, the ERISA plan should bear the burden of proof by a preponderance of the credible evidence when imposing a limitation on a participant who otherwise qualifies for benefits absent the limitation.
Excuse me, Mr. Feigenbaum. I have two questions. Answer them in whichever order you prefer.
Yes,
My
Your Honor.
first question is, why should we go near the burden of proof issue? The facts are not really disputed in this case. It's a question of what those facts add up to. Do those facts add up to a condition that does or does not fall within the limitation of the policy? That's simply a question of interpreting the limitation clause. It's not a question, as I see it, of burden of proof. And my second question is, if we were to adopt the proposed definition that you just read, my knowledge of insurance policies, which is not encyclopedic, but which comes from some years of experience, is that I can't begin to tell you the number of clauses, covenants, sentences, and the like in the typical insurance policy that could, particularly by an artful lawyer, be characterized as limitations. So I wonder just what kind of Pandora's jar we're opening up if we bought into that definition.
Your Honor, to answer your first question, I think the case can be resolved by adopting Weizenkamp and Chronister, and that the evidence is actually overwhelming, given that Unum conceded she had fibromyalgia and Unum conceded she couldn't work.
And if we think Weizenkamp is wrongly decided, the case can also be decided without it going to the burden of proof. That's my whole point, that this is simply a question of measuring what everyone agrees are the symptoms, the loss of function, the results of this 18-point testing, and measuring that against the policy language and coming out yay or nay. So I'm struggling with the notion, and have been since getting the secretary's brief as to why we should wade into this burden of proof issue gratuitously.
May I answer, Your Honor?
Sure.
Sure. So 2 reasons. One, Unum's position is under the plan terms, it's a limitation. And somehow Professor Ovist had to prove what I'd call a negative proposition, that she has to show that she doesn't fall under this limitation. These limitations and exclusions show up in these plans. And I understand the Serbonian bog quagmire that you're suggesting might develop because of traditional insurance law. But these plans contain exclusions and limitations. The district courts have wrestled with it. I argued this for the first time in a case, Gent versus Cuna, and the panel decided, actually, I think Judge Selly, you were on the panel, decided that would pass on it. And it's come up 3 other times, and I see comments from
credit for consistency then, right?
Yeah, okay. But Your Honor, I see district courts on occasion saying
you left me out too. I've passed on the question because I thought it was an extremely hard question not to be reached unless necessary.
Your Honor, you passed on it twice in Dukovic and I think Aruda. And well, for example, if we go to Aruda, Judge Woodlock raised it and said, hey, this is a thorny issue. How do we resolve this? And I'm suggesting that the First Circuit provide some level of clarity to the district courts.
You may not like the clarity we provide if we were to get there. Anyway, what's wrong with the Supreme Court providing some clarity?
It's never wrong, Your Honor.
All right. Anything else?
No, I think Mr. Toomey said I've gone over my time, so I'll wait. Thank you very much.
Thank you.
Mr. Feigenbaum, you can mute your device at this time. Attorney Hamilton, if you could unmute your device. And please introduce yourself on the record again, please.
Thank you, Mr. Toomey. Good afternoon, Your Honors. Joseph Hamilton for the appellees, Unum Life Insurance Company of America and Unum Group. I'll jump right into the Weizenkamp issue, if you will, Your Honor. I think to get there, it's important to emphasize that Ms. Ovist's disability arose from 3 conditions: chronic fatigue syndrome, depression, and fibromyalgia. And when you review the record, you will see that during the administration of the claim, the primary condition being set forth by her physicians was the chronic fatigue syndrome, with the fibromyalgia being a secondary diagnosis. Then in 2012, the major depression became a factor as well. Now, in the last 20 years, this court has addressed, I think, all 3 of those conditions and numerous times in the context of an ERISA benefit claim. As far as the mental illness goes, Ms. Ovist, psychologist, did file a report saying she was unable to work at all due to major depression. And that would be within the limitation provision. That's been addressed a couple of times by the court, Ghent in 2010, and Dukovic has been mentioned as well in 2015, both upholding the limitation provision for a mental illness disability. With regard to the chronic fatigue syndrome and the fibromyalgia, this court's addressed that as well. And I think the Weizenkamp case, as well as Ms. Ovist tying her case to that decision, is contrary to the direction given by this court going back to 2003. And the decisions, and there's multiple ones, have all said that chronic fatigue syndrome and fibromyalgia do not lend themselves to objective clinical findings.
But have we ever said that in a case in which this 18-point testing has been proffered in as a proof that there is some test for fibromyalgia?
So here's how it came up, Judge. In the Denmark case, which I believe you wrote the opinion in 2007, the court noted in more than once in the decision is noted that Ms. Denmark was found to have a positive trigger point test. And despite that, and I think Mr. Fagenbaum said he represented Ms. Denmark in that case. Ms. Denmark argued in that case that it was unreasonable to require her to produce objective evidence of her inability to work. And that's with the existence of the 18-point trigger test. So this court had that information in front of it. Ms. Denmark had that information, and neither in that case or in any of the other cases that this court has decided has that been found to be an objective indication of fibromyalgia. In fact, in Denmark, this court held that fibromyalgia, along with chronic fatigue syndrome, are conditions that are not subject to objective verification because it is a condition lacking abnormalities in blood testing or specific abnormalities in physical exam. And the conundrum has always been that, yes, you can touch these various points and say, does that hurt? Does that not hurt? And the patient can respond, but at the end of the day, you're relying completely on their self-report, which when you look at the provision of the plan, Your Honor, it states that the manifestations of the condition, that is the pain, the fatigue, has to be verified by, that's a series of tests, diagnostic, clinical examinations, et cetera. So while this trigger point test, which really is being de-emphasized by the American College of Rheumatology, is used, that does not make it a clinical examination that verifies, because as this court has repeatedly found, you can't verify it. So ERISA plans have gone forward since 2003. And in fact,
remaining.
Thank you. And in fact, administered these claims in exactly the way that this court has instructed to do, to say, we know there is not objective evidence clinically on these things, so we have to rely on what are the functional limitations.
So do you do it differently depending on where the claimant lives? I mean, do you apply the SRS limitation in a different way depending on where the insured happens to reside?
Well, I can't speak for the company nationally, Your Honor. I do know that if we were my understanding is no, unless there is a direct, such as Weizenkamp, if we went before that court, we would be required to do, unless we could convince the court to overturn that decision.
So now,
but that's unlike.
So now claimants insured by Unum in different parts of the country face an inconsistent application of that limitation, right?
Yes, I would say the majority of the decisions, Your Honor, apply it exactly the way that we do, and that Weizenkamp is the outlier. It's not the norm. And the reason for it, that Weizenkamp is the outlier, is that it has taken this position that's contrary to what most other courts have found, is that this one single test is not a verification of the condition. You can't, because what we then are left with is tomorrow, anyone with that alleges they have fibromyalgia can go in, get this one clinical examination, then file a claim and say, okay, I have this diagnosis based upon these 18 points. My doctor says I can't work. Based upon that, case is over, and we're basically back to where we were before 2003, in which I think everyone has agreed that this is not a condition. And rheumatologists have been struggling with this for 20 years. And the current view, based upon the American College, is it's a pain index, it's a rule out other conditions, how long have you had it? So it's this diagnosis by exclusion, and that's specifically what this provision is entitled is meant to do. The other thing
but there is still, Judge LaPlante has put his finger on an inequity, because what you've created is a situation where if Mr. Feigenbaum had decided to file his case in the Northern District of Illinois rather than in the District of Maine, his client would probably be entitled to this coverage.
Well, we had a venue discussion in this case, Your Honor. We probably would have had one then. Yeah. And my position, Your Honor, is that just because the Seventh Circuit, in our view, has made an error, does not mean that this circuit should just go along with it simply for that reason.
Well, that's probably true, but wouldn't it make more sense in view of the Seventh Circuit decision and the Eighth Circuit decision, simply for Unum to clarify the policy language a little? Well, easy enough to exclude this trigger point testing.
Yeah,
by specific reference.
Yes, Your Honor. That's always the point made by claimants, is that if you don't specify and you could have, that somehow the plan is deficient. The problem is you then, once you specify one and you haven't specified others, now you say, well, you specified that one, but you didn't specify this one, and it becomes a real problem. So the standard here is whether or not the company has made a reasonable reading, a reasonable interpretation of the plan. The discretionary language in the plan specifically grants to Unum Life the authority to interpret the plan limitation. Every district court in this circuit that has looked at this has upheld the interpretation that was made in this case. So it's not as if, and those go before and after Weissenkamp. So it is not as if this provision has been applied without some support, not only within this circuit, but within others. So I would strongly request that this court not feel it is somehow bound by Weissenkamp, which we think is an inappropriate decision. If Ms. Ovist had filed in her circuit in Florida rather than coming up to Massachusetts, the law is similar there as it is here. She didn't choose to go to Wisconsin. She chose to come here to Massachusetts. But we think the guidance that this court has given since 2003 as to how to treat these conditions is the way to go. And the last thing I would say is, not until this appeal has been filed has fibromyalgia become the headliner in terms of the reason for the disability. The mental illness has been there since 2012. The chronic fatigue syndrome has been there since day one.
Counsel, you've now circled back to your opening argument.
All right.
You've run out of time. Thank you very much.
Thank you, Your Honors.
Attorney Hamilton, at this time, if you could mute your device. Attorney Liu, if you could introduce yourself on the record.
May it please the court, Katrina Liu for the Secretary of Labor as amicus curiae. As you know, the Secretary is here to weigh in on the question of burden shifting for limitations, and the Secretary's position is that the burden should rest with the plan. Now, Judge Lynch, you are absolutely correct that this is not an easy question. So the Secretary's role here is to assist the court. I want to address the question.
Why doesn't the Secretary go to Congress if it wants a nationwide rule rather than making arguments to individual courts of appeals?
Yeah. So the question of how to assign the burden is really a judicial function.
Doesn't have to be. Congress
That's
can
true.
easily specify it, or you could ask the Supreme Court to take a case and come up with a national judicial rule. But to the extent people are worried about lack of uniformity, seems to me you're inviting even more of it.
Yeah. So the Secretary's powers essentially are, so the Secretary doesn't legislate, right? So, and the relationship with Congress is not, it is not typically our position to propose some rule for uniformity. Generally, the way ERISA is implemented is that there's a body of federal common law that develops under the statute that Congress did enact. And it is this federal common law that ensures the uniformity of the administration of ERISA plans nationwide. And so the Secretary's role here is to ensure that this enforcement of these ERISA plans is one that's taking place uniformly, because one of the benefits of ERISA, particularly for employers and plans, is that certainty of that uniformity.
But even the Secretary would agree, I would think, that the federal courts should not reach out to decide issues gratuitously. That is, to decide issues when it is unnecessary to decide that issue to resolve a particular case.
Yeah, so I wanted to answer this question of yours, Joselia, and so to be clear, the Secretary has no position on whether this court must decide the issue, but there are reasons why it may want to. So the first is that the Sixth Circuit has now weighed in specifically on this burden shifting question and found that for limitations, the plan should have the burden to prove them.
But that has nothing to do with whether it's necessary for us to decide the burden of proof issue in this case.
Yeah.
That is important in terms of the development of the law in the direction you'd like to see it develop. But my concern, frankly, isn't whether your position is right or wrong. My concern is with judicial restraint, with whether this court should plunge ahead at the Secretary's request and decide an issue that we don't have to decide in order to resolve the case in controversy that is before us.
So specifically to this case, so the Secretary, again, takes no position on whether the court has to, but the burden in this specific case, it may matter, it may not. So the district, what we know though, is that the district court made an explicit ruling that the burden to prove the SRS limitation rested on Ovist, which is part of its—
Pardon me. So is your fallback position that even if the Court of Appeals finds we don't have to decide the issue, that we should vacate the district court ruling on that point? Is that your fallback position?
Your Honor, if this court vacates, it should articulate the proper legal rule for the district court to apply. So the
No. That's not the question I asked you. Why would we refrain from? You're assuming that we want the question answered. I don't recall your brief saying even if you don't answer the question, you should tell the district court the question's still open.
I see.
5 minutes remaining.
Yeah, Your Honor, the Secretary has no position on what the court must do if it does not decide this question.
Okay.
And so if it does decide the question, though, the remedy then would be to articulate the proper legal framework for burden shifting and then to remand to the district court to determine in the first instance whether the burden shift impacts the case. So I also wanted to address Judge Celia's second question, which was the idea that depending on how we assign the burden, this could open up a Pandora's box. And it could end up in a lot of confusion for plans and for participants, and understanding who has to prove what, and what a provision actually is. So that confusion already exists. We have a split among district courts, some that assign the burden to the participant, some to the plans.
Pardon me, but I'm not sure you quite grasp the point. You think it's self-evident what a limitation is. However, insurance policies have a lot of different terms. There is a coverage provision that may be subject to limitations, but still considered part of coverage. Then there are exclusions. Then there are endorsements. I just decided a environmental insurance case where some endorsements are labeled limitations on coverage that is granted. Some endorsements are labeled exclusions, and none of them are contained in the basic policy. So the Pandora's box that Judge Selya is talking about is very real. Not only is it a Pandora's box for ERISA cases, but it's a Pandora's box because your underlying principle has to do with the common law of insurance. And different states have different common laws of insurance.
Okay, Your Honor, yes, you're right. And I believe the case you're referencing is performance transportation. Okay, I understand the question now. The issue when reading plan terms of whether that term is a term of coverage or an exclusionary term or an endorsement, this would be a task for courts that would not be new, regardless of how this court decides on the burden issue. So plans can be written in many different ways, and the court's role then is to interpret the plan provision to determine whether it is a term of coverage. And if it is a term of coverage, the participant bears the burden of proving she's entitled to coverage.
Yes, and your position in this case appears to be that a policy that labels this as a coverage term of the policy, nonetheless, because it contains a limitation, is not a coverage term, correct?
Your Honor, the Secretary's position is that a limitation is its own type of provision.
Regardless of where in the policy it is, and
Correct.
Regardless of how the agreed upon language of the policy characterizes it.
That's correct. It is yes, and we see a provision as a limitation or a term of coverage or an exclusion depending on how that term functions. So it's not dependent
but it's not as easy as that, counsel, because a coverage term, depending on how it's written, may contain within it limitations, because coverage terms have very specific definitions and have exceptions within those definitions, which a lawyer could very easily and probably understandably characterize as limitations. And I think what both Judge Lynch and I are suggesting to you is that we regard this burden of proof problem, particularly using the definition or the proposed language that Mr. Feigenbaum gave us during his argument, as considerably more nuanced than either he regards it or than your brief indicates the Secretary of Labor regards it.
Certainly there are difficult, close cases where is part.
Finish the thought.
Sure, yes. Where it's difficult to distinguish between a term of coverage or a limitation or an exclusion. that is not a test that the court need address here, because it is undisputed that the SRS limitation is a limitation. The question, though, is whether you treat it like a term of coverage in that the participant needs to bear the burden, or treat it like an exclusion in which the plan must bear the burden.
Okay, so we've got the argument. Thank you very much.
Thank you.
Attorney Liu, you may mute your audio and video at this time. Attorney Feigenbaum, you have 2 minutes. Please reintroduce yourself to the record.
Jonathan Feigenbaum again for the appellant Rhonda Ovist. A few quick comments I'd like to make. My colleague, Mr. Hamilton, seemed to be insinuating at some level that one of the concerns of the planned fiduciary about these self-reported symptoms based claims is that some of the claims are fake. Maybe in some instances, but not this case. As I would like to remind the court, Unum had 3 of its doctors admit or concede that Professor Ovist had fibromyalgia, and in its final adverse benefit determination, Unum conceded she couldn't work. So any issues of sneaky behavior or phony claims just aren't based in reality on this claim. The other point I'd like to make is looking at the self-reported symptoms language, what it excludes is claims that are not verifiable using test procedures or, quote, clinical examinations standardly accepted in the practice of medicine. And as I've repeated, as the 7th Circuit found, the 8th Circuit found, trigger point testing is a clinical standard exam. There's other well-known illnesses, Alzheimer's. You really can't diagnose that until after someone's dead and you look at their brain under a microscope. Same kind of thing for chronic traumatic encephalopathy. Can't really make a definitive diagnosis until after death. But those are types of medical conditions that I think we could all agree that are diagnosed clinically. I could probably go on and name a number of other ones. But the point is that Unum's language uses this term, clinical examination, standardly accepted in the practice of medicine. And that does not mean that the claimant has to show a laboratory type test for some condition for which there is none.
That's time.
Thank you.
Thank you all. Thank you.
That concludes the arguments for today. This session of the Honorable United States Court of Appeals is now recessed until the next session of the court. God save the United States of America and this honorable court. Counsel, you may